Please introduce yourself. Shambhavi.
Sir, I am Shambhavi, and I have done my schooling from Gorakhpur, and I have done my BA LLB from University of Allahabad. I completed the course in 2019.
Bit slow, beta, bit slow, huh? Bit slow. Go easy. As you are going to, as you, hello, as you are going to give the interview on the board, just try to imitate here. Huh? Just bit slow.
So,
Start.
Thereafter, I did LLM, which I completed in the year 2022.
LLM from where?
Sir, from Gorakhpur.
Gorakhpur. And what is the topic of dissertation? What was your topic?
So, topic of my dissertation was right to privacy in the present situation of information technology.
Okay. Suppose right to privacy
Yes, sir.
is conflicted to the right to know. Which right would be prevail?
Sir,
And why?
Sir, in this case, we would apply doctrine of proportionality, and we will see that social interest is promoted. In whichever case the social interest would be promoted, we will apply that right.
Very good. And what is your area of interest in the law?
Sir, Indian Evidence Act.
Any other law?
Sir, you can ask from any law, sir. Contract, CRPC, sir.
Right. So what is the Solus Agreement, Shambhavi?
Yes, sir.
Have you heard about this stuff?
Yes, sir. So, Solus Agreement basically is an exception to Section 27 of the Indian Contract Act, and it says that traders, manufacturers, they enter into agreement to regulate the price of the goods and to see that no one is putting any very high price on the goods. For that purpose, agreement can be entered into, and that agreement is not barred by Section 27 of the Contract Act.
Very good. And what is the Subratio Veri in Indian Contract Act? Subratio Veri.
Sir, I've read it, but I'm not able to recall it. If you can give some hints.
Okay. In a fraud.
Fraud. Sir, fraud means that if someone, he tells any statement which he believes to be false, or if he gives any statement which is fraudulent by nature, or which is barred by any other law, so in that case fraud would be committed. And also present concealment of fact would also be considered as a fraud.
That is a Subratio Veri, okay?
Yes.
Active concealment of a fact.
Yes, sir.
And what is the Suggestio Falsi in the same section? Suggestio Falsi?
So suggestion, I think, sir, it would mean suggestion of any fact, knowing that it is false, but still suggesting such facts.
And whether silence amount to fraud?
So, as a general rule, silence would not amount to fraud, but there are certain exceptions to it, like where there is duty to speak. In that case, silence would amount to fraud. Also, when there is change of circumstances, in that case also, the silence would amount to fraud.
Okay, have you heard the term about the media trial and how the media trial affect the criminal justice system?
Yes. So, media trial, so it would mean that when the facts of a case is presented before the public through the media, and it is given open to the public to make certain assumptions regarding it. So it has very negative impact on the criminal justice system, because it negates the principle of innocence of the accused, because prior to he is convicted or he's acquitted in the court, through public opinion he's declared as an accused, and it also it, at some extent it jeopardizes the investigation which is done by the police, because sometimes police gets in the direction of public opinion, so popular public
Very
opinion.
good. And what do you understand by joint tortfeasor?
Sorry, sir.
Joint tortfeasor.
Joint tortfeasor.
Yes.
So it would mean when two or more persons, they collectively do certain thought and cause harm to a single person, then they would be called joint tortfeasors.
And what is an independent tortfeasor?
So independent tortfeasor would mean that even though they are committing a certain act, but they have not done it jointly.
Very good. So what is your opinion about the UCC?
Sir, according to me, UCC, so UCC would mean bringing same laws for all the citizens of India. So I think it should be implemented because of many good points. So one would be that through different laws of different communities, certain alternate judicial system gets created in which the court has to look into personal laws of all the communities, and also, sir, there are many laws which are derogatory, discriminatory towards the women, so that laws would get abolished, and also, sir, it would to some extent it would create equality in the society, and if we look at the larger picture, it can lead to national integration.
By what ways it will bring unification in a nation? How it just to create equality and integrity or unification in India?
Yes, sir. Sir,
Give me three points specifically.
yes, sir. Sir, I would say that Article 14 says that there should be equality before law and equal protection of law. Sir, through a single system, there would be Article 14 would be promoted, and sir, also the mainly the women who are discriminated due to many the laws of personal laws, so they would get a sense of equality in the society, and also, sir, the certain backward classes of people, sir, if a unified system of law is brought, they will
Okay, as we know that Sambhavi, okay, as we know that the Supreme Court is a guardian of our constitution. Can you give me two judgment which enhance the social justice in our society recently which is passed?
So social justice first would be, sir, sir, in triple talaq case, in which it was said that it has held it unconstitutional as it is violative of Article 14 and Article 21 of the
Give
Constitution.
me the name of case.
The Saira Banu versus Union of India.
And another one?
So another one would be Young Lawyers Association versus Union of India, which is famously known as Sabrimala case.
Okay. Right of private defense when extend to causing death against the body. What are the conditions?
Sir, it has been mentioned under Section 100 of the Indian Penal Code. It says that when apprehension of death is caused, or apprehension of grievous injury is caused, or such an assault which can lead to kidnapping or abduction of the person, or unlawful restraint of the person and administering acid upon the person, in that cases the right to private defense extend to causing death of that other person.
You have mentioned here only the 5 grounds. 2 grounds are left.
So one is also unnatural lust and rape.
Okay. So, Section 377 of the Indian Penal Code is a decriminalized. Okay. So, in a Section 100, there is a ground is still available in a right of private defense. You can cause a death. Is it possible? Because how?
Sir, because it in section 377, what is decriminalized is consensual having intercourse between same sex persons, but section 100 it says that if it is forced upon that person, then that person can cause death.
Very good. Thank you, sir.
Thank you.
Thank you, beta.
जसवाल जी
जी शाबजी,
Yes, sir.
आरटीआई तो आपने अपने उसमें स्टडी किया है। आरटीआई में कुछ इंफॉर्मेशन को डिनाई भी किया जाता है, कहाँ प्रोविजन है ये?
सर ये सेक्शन 8 में है ऑफ राइट RTI Act के सर जो the new bill which has sir new act which has been passed by the parliament sir to some extent it has led to it has diluted section 8 of RTI Act also, so it has been alleged. So
सेक्शन 8 वेरी गुड। सेक्शन 9 और 24 में भी इंफॉर्मेशन डिनाइल के कुछ ग्राउंड्स दिए।
सर एक्चुअली मैंने वो आरटीआई एक्ट का अपने डेजर्टेशन में नहीं डाला है सर, क्योंकि मैंने बेसिकली सर ये एक्ट आ गया था तब तक जब तक मैंने डेजर्टेशन बनाया था, तो बेसिकली मैंने वो डाला है और राइट टू प्राइवेसी सर बाकी इंटरनेशनल और नेशनल लेवल पे सर मैंने आरटीआई
ओके शामिल एक्स्ट्रा टेरिटोरियल ज्यूरिसडिक्शन का प्रोविजन क्रिमिनल लॉ में कहाँ पे है?
सर आईपीसी में सेक्शन 3 और 4 मेंशन करता है एक्स्ट्रा टेरिटोरियल जुरिडिक्शन को।
और कहीं प्रोसीजर में भी है?
सर प्रोसीजर में सर सेक्शन मुझे याद नहीं आ रहा है, पर आई थिंक सर 183 सेक्शन या 180 सर सेक्शन मुझे याद नहीं आ रहा है।
ओके 188। शाम्भवी, आप आईसी में मिस्टर ए और मिस्टर बी, जो मिस्टर ए यूके के हैं और मिस्टर बी जो है फ्रांस के, और जो शिप है यूएस की है, फ्लैग भी उस पर यूएस का लगा हुआ है। वहां क्या होता है कि लोगों में सडन फाइट हो जाती है और ए बी को डेथ कास्ट कर देता है। तो क्या कोई ऐसी सूरत है जिसमें यदि मिस्टर ए इंडिया में भाग के चले आते हैं तो उनको पेनलाइज किया जा सकता है, और कर सकता है तो कौन कर सकता है? प्रोसीजर क्या हो?
सर उस सिचुएशन में सर अगर वो शिप जो है वो सर इंडियन शिप है, तो उस केस में सर यहाँ पे जहाँ पे भी वो इंसान पकड़ा जाएगा वहां पे जुरिडिक्शन होगा उसको वो प्रोसिक्यूट करने का।
नहीं, इस इलस्ट्रेशन में भाई कोई भी इंडियन इंग्रेडिएंट नहीं है, तो भी क्या जो नेटिव स्टेट जो भी क्लेम करती है, चाहे यूके, फ्रांस या यूएस, वो इंडिया में है वो, तो उसको पनिश करने के लिए क्या प्रोसीजर हो सकता है? यदि किसी भी तरह उसको कानून के दायरे में लाया जाए तो क्या प्रोसीजर हो सकता है? क्या वैसे ही अनपनिश्ड रह जाएगा वो?
नहीं सर सर उस केस में सर सेक्शन 3 ऑफ आईपीसी कहता है कि अगर इफ ही हैज कमिटेड एनी क्राइम जो कि इंडिया में पनिशेबल ऑफेंस है पर जहां उसने किया है वहां में भी ना हो, तो अगर वो इंडिया में
आप शाम्भी आपने जवाब दे दिया है। इंडियन लॉ के हिसाब से वो उसके अगेंस्ट में प्रोसीड नहीं किया सकता, तो कोई तो ऐसी प्रोसीजर होगी ना जिससे उसको पनिश किया जा सके।
सॉरी सर मुझे अभी ध्यान
एक्स्ट्राडिशन के लिए वो कंट्री नहीं डिमांड कर सकती है?
हाँ सर, एक्सट्रेडिशन के लिए कर सकती है।
तो तब तो पनिश हो सकता है ना। चलो ठीक है। शाम्भवी, एक्यूज जो है कंप्लेंट विटनेस हो सकता है, तो क्या एक्यूज को कंपेल भी किया जा सकता है एज ए विटनेस प्रोड्यूस करने के लिए?
सर इसमें दो सेक्शन देखेंगे सर, एक सेक्शन 315 और सेक्शन 313 ऑफ द क्रिमिनल प्रोसीजर कोड। सर 315 में कहा गया है कि अक्यूज्ड कैन बी अ कॉम्पिटेंट विटनेस अगर वो खुद से रिटन में देता है कि उसे विटनेस देना है, पर उसे अगर कंपेल करना है तो सर 313 में करेंगे, और वो सिर्फ उस केस के लिए करेंगे ताकि वो आके अपना केस को एक्सप्लेन कर सके। उस जो एविडेंस जो भी वो बोल रहा है उसको सर एक सब्सटैंटिव पीस ऑफ एविडेंस की तरह उसके केस में नहीं लिया जाएगा।
क्या 3 और 13 में वो जो उसका स्टेटमेंट रिकॉर्ड होता है वो एज एविडेंस ट्रीट किया जा सकता है, और क्या उसको वीकनेस मानेंगे?
सर उसको एज अ एविडेंस सर ट्रीट करा जा सकता है उस केस में भी, और किसी और केस में भी उस स्टेटमेंट को एज अ एविडेंस ट्रीट से यूज किया जा सकता है, पर उसके बेसिस पे उसको सर प्रोसिक्यूट नहीं कर सकते हैं
प्रोसिक्यूट?
सर, मतलब उसको कन्विक्ट कर सकते हैं। सॉरी, मैंने गलत वर्ड बोल दिया।
क्या कोई कॉन्स्टिट्यूशनल गारंटी भी है कि उसको?
यस सर।
कहाँ है प्रोविजन?
सर आर्टिकल 20 में दिया हुआ है कि नो पर्सन कैन बी कंपेल्ड टू गिव विटनेस अगेंस्ट हिमसेल्फ।
ओके। और एक्यूज यदि अपने को एग्जामिन कराना चाहता है तो सीआरपीसी में कौन सा प्रोविजन उसकी हेल्प करेगी?
सर अगर वो खुद को एग्जामिन कराए तो 315 ऑफ सीआरपीसी सर तब उसमें आएगा।
राइट राइट राइट। ये 319 बड़ी इसकी भी चर्चा होती है, क्या है इसमें कुछ खास?
हाँ सर। सर 319 सर इट सेज दैट अगर जज को लगता है कि जिन लोगों का नाम चार्जशीट पे है उसके अलावा भी किसी को बुलाया जा सकता है, उसके उसे भी वो भी अक्यूज हो सकता है, तो सर कोर्ट उससे समन कर सकता है और उसका ट्रायल अलग से करा सकता है उसी केस में।
वेरी गुड वेरी गुड। शाम्भी, आप एविडेंस एक्ट, ये आपको ज्यादा कंफर्ट होंगे उसमें? आपने बताया एविडेंस एक्ट पर अच्छी पकड़ है आपकी।
हाँ सर।
वेरी गुड। ये सबसे इंपॉर्टेंट सेक्शन आपको क्या लगता है एविडेंस एक्ट का?
सबसे इम्पोर्टेंट सेक्शन सर मुझे लगता है कि 165 एविडेंस एक्ट का।
क्या है 165?
सर 165 कहता है कि जज को भी सर एक्टिव इन्वॉल्व होने का सर मौका देता है उस केस में। जज चाहे तो कोई भी डॉक्यूमेंट प्रोड्यूस करा सकता है या किसी भी विटनेस को एग्जामिन कर सकता है, जो भी मतलब रेस्ट्रिक्शंस पुलिस पे या फिर कोर्ट के प्रोसीडिंग्स पे लगे रहते हैं, उस अगर जज को लगता है कि जस्टिस इम्पार्ट करने के लिए वो स्टेटमेंट या डॉक्यूमेंट जरूरी है तो वो मंगवा सकता है।
अच्छा, ये उस पे ये भी लिखा है किसी को बुला सकता है, कुछ भी पूछ सकता है, तो क्या आपको लगता है कि वो जस्ट बिल्कुल ऑलमाइटी है, जो चाहे कर ले, उसमें कोई रिस्ट्रिक्शन 165 पर नहीं है?
नहीं सर, एक्सेप्शन सर एक्सेप्शन दिए हुए हैं सर। उसमें है कि जो भी प्रिविलेज्ड कम्युनिकेशन है 121 से लेके 126 तक सर वो उसको नहीं बुला सकता है, और कोई ऐसे क्वेश्चंस जो कि 148 में बार्ड हैं वो या तो इनडिसेंट है, वो सब क्वेश्चंस सर नहीं पूछ सकता है, और जो भी वो जजमेंट देगा वो सिर्फ रेलेवेंट फैक्ट के ऊपर ही देगा, भले उसने इररेलेवेंट फैक्ट्स पे भी लोगों को एग्जामिन किया।
ओके, गुड गुड। शाम्भवी,
यस सर।
सेक्शन 27 में जो एक्यूज के स्टेटमेंट पे रिकवरी होती है, वो किस एक्सटेंट तक रिलेवेंट है?
सर जो रिकवरी होती है सर वो ए- अ, सर वो हाँ सर इन द एक केस है सर, उस केस पुलुकोरी कोटैया वर्सेस एम्परर। सर उस केस में कहा गया था कि सिर्फ उतना स्टेटमेंट रेलेवेंट है जितने से डिस्कवरी ऑफ सर्टेन फैक्ट्स हो रही हो। फॉर एग्जांपल सर, अगर किसी पर्सन ने बोला है कि आई हैव किल्ड ए एंड बी विथ दिस ऑब्जेक्ट एंड आई हैव हिडन दैट ऑब्जेक्ट इन सो एंड सो प्लेस, तो सिर्फ उतना पार्ट रेलेवेंट होगा जिससे कि वो पर्टिकुलर वेपन की डिस्कवरी हो रही है, और ना कि वो पार्ट जिसमें उसने कन्फेस किया है कि उसने मर्डर किया है ए एंड बी का।
वेरी गुड। शाम्भवी, एक
यस
एक्यूज पुलिस के सामने कन्फेस नहीं कर सकता?
सर, पुलिस के सामने वो कन्फेस तो कर सकता है, पर वो से इट विल बी हिट बाय द रिस्ट्रिक्शंस प्रेजेंट इन सेक्शन 25 ऑफ द एविडेंस एक्ट, जो उसको इनएडमिसिबल बनाता है सर उसे कन्फेशन को।
कोई ऐसी सिचुएशन है जिसमें एक्यूज का कन्फेशन एडमिसिबल हो जाएगी, रिलेवेंट हो जाएगी?
यस सर, अगर वो पुलिस कस्टडी में हो और ही मेक्स द कन्फेशन टू मजिस्ट्रेट अंडर सेक्शन 164 ऑफ सीआरपीसी, सर उस केस में रेलिवेंट होगा। और अगर अंडर सेक्शन 27 अगर कोई ऑब्जेक्ट उससे डिस्कवर हो जाता है, तो सर इन दोनों केस में रेलिवेंट हो जाएगा वो कन्फेशन।
ओके, क्रॉस एग्जामिनेशन का क्या पर्पज है?
सर क्रॉस एग्जामिनेशन का पर्पज है टू ब्रिंग आउट द ट्रूथ ऑफ द स्टेटमेंट जो भी विटनेसेस ने दिए हुए हैं एग्जामिनेशन इन चीफ में।
तो क्रॉस एग्जामिनेशन तो एडवोकेट के, डिफेंस के एडवोकेट के पास तो बहुत बड़ा हथियार है। वो बिल्कुल अनलिमिटेड वे में जो है कुछ भी पूछ सकता है। क्या उसकी भी कुछ लिमिट है?
यस सर, सर लिमिट्स दिए हुए हैं कि सर वो कोई सर 148 में दिया हुआ है सर, सेक्शन 148 में कि तीन चार ग्राउंड्स दिए हुए हैं सर कि अगर वॉट एवर imputation the other party is trying to prove, it should have a reasonable nexus with what sir relevant fact। अगर वो highly improbable या कोई उसमें nexus नहीं है तो नहीं prove कर सकता है। एंड ऑल्सो सर indecent और scandalous questions या तो ऐसे क्वेश्चन जो सिर्फ annoy करने के लिए पूछे जा रहे हैं, तो उस पर सर कोर्ट रेस्ट्रिक्ट कर सकता है।
बहुत बढ़िया। मतलब आपका जवाब ये है कि लिमिटेशन है, और आपके जो है जगह जगह उसके प्रोविजंस दिए हुए हैं, जैसा कि आप बता रही है कुछ प्रोविजंस। वेरी गुड। शाम्भवी,
जी सर।
इधर डाइवोर्स के मामले तेजी से ग्रो कर रहे हैं। क्या है इसके पीछे का रीजंस क्या है, और उनको कम करने के लिए क्या सजेस्ट करेंगे आप?
सर रीजंस हो सकते हैं कि सर बेसिकली जो ग्राउंड्स दिए हुए हैं सर हिंदू लॉ में या मुस्लिम लॉ में, उस पे डिवोर्स होता है। और सर एक न्यू कॉन्सेप्ट आ रहा है, इरिट्रीवेबल ब्रेकडाउन ऑफ मैरिज। सर उसके केसेस ज्यादा इसलिए बढ़ रहे हैं क्योंकि सर टू माय ओपिनियन सर अब सर पीपल आर नॉट दैट कॉम्प्रोमाइज।
नहीं शाम्भवी, मैं आपसे क्वेश्चन ये पूछ रहा हूं कि आजकल ये डाइवोर्स के केसेस इतने ज्यादा क्यों बढ़ रहे हैं? दूसरा क्वेश्चन ये है कि आप उन्हें कम करने के लिए सोल्यूशन के लिए क्या सजेस्ट करना चाहेंगे? तो पहले क्वेश्चन पे आते हैं, क्यों बढ़ रहा है? हाँ शाम बताइए
सर
आराम से।
सर पहले क्वेश्चन का तो सर ये आंसर हो सकता है कि सर पीपल सर पहले उतना सर ऐसा माना जाता था कि मैरिज एक सेक्रेड, मैरिज इज अ सेक्रेड इंस्टीट्यूशन, और उसमें डिवोर्स लेना वाज नॉट दैट एक्सेप्टेबल इन द सोसाइटी. बट अक्सर सब लोग, अगर इफ दे आर हैविंग एनी प्रॉब्लम इन द मैरिजेस, सो दे आर कमिंग फॉरवर्ड टू डिसॉल्व द मैरिज. सो यही रीजन हो सकता है सर. सबको अपनी अपने इंडिविजुअल राइट्स सर ज्यादा होने वो है सर.
क्या सजेस्ट करना चाहेंगे सोसाइटी को?
सर sir, I would suggest, I would suggest that they, to some extent, they should give a chance to their marriage, and only if they feel that it has gone to an extent that reconciliation is not possible, sir, तभी वो divorce के तरफ जाएं.
कानून में भी कई तरह की कोशिशें की गई हैं, ट्राई किया गया है, कई फोरम्स दिए गए कि डाइवोर्स अल्टीमेट रिजल्ट हो, और उसके पहले कोशिश कर ली जाए कि मैरिज सेव रहे. ये कहाँ पे है ये सब प्रोविजंस?
सर हिंदू मैरिज एक्ट में दिया हुआ है सर, सेक्शन 14. सर वो कहता है कि सर जो भी डिवोर्स एप्लीकेशन है वो विद इन 1 ईयर ऑफ मैरिज उससे नहीं एक्सेप्ट किया जाएगा. और अगर कोई पार्टीज आ भी रहे हैं सर डिवोर्स के लिए, तो एक कूलिंग पीरियड कहते हैं सर 6 मंथ का, उसे देना चाहिए कि अगर उस टाइम में कोई रिकंसिलिएशन का चांस हो तो वो हो सके. और सर एक ग्राउंड है सर, वो है जुडिशियल सेपरेशन का, कि सर अगर इफ पार्टीज थिंक दैट उन्हें डिवोर्स लेना है, तो सर कोर्ट कह सकता है कि जुडिशियल सेपरेशन इज बेसिकली नॉट रिपुडिएशन ऑफ मैरिज बट रादर सस्पेंशन ऑफ मैरिज. कुछ टाइम वो ऑफ ले लें और उसके बाद अगर उन्हें लगता है 1 साल तक, तो वो रिकंसाइल कर सकते हैं.
498 का केस हो जाता है, डाउरी का केस हो जाता है, तो वहां पे भी कुछ मैरिज को बचाने की कोशिश की जाती है क्या?
सर डाउरी केसेस में सर सर आई एम सॉरी, मुझे आई एम नॉट एबल टू रिकॉल इट.
उसमें मैं ये आपसे पूछना चाहता हूँ कि क्या दोनों पार्टी को, जो हस्बैंड की फैमिली है और जो जो वाइफ है उसकी फैमिली है, तो उन दोनों को बिठा के कोर्ट किसी तरह का निगोशिएशन या मीडिएशन भी करवाती है क्या?
यस सर, कराती है सर.
और उसके आधार पे केस में फाइनल रिपोर्ट भी लग जाती है, पता है आपको?
जी हाँ सर, मैंने इंटर्नशिप भी की है सर हाई कोर्ट मीडिएशन सेंटर में.
कैसे करते हैं इसको?
सर वहाँ पे सर सीनियर एडवोकेट्स रहते थे सर, और वहाँ पे वो लोग दोनों पार्टीज को सुनते थे और एक बीच का सोल्यूशन निकालने की सर कोशिश करते थे. और अगर कोई पार्टी एग्री हो जाती थी तो फिर सर वो उसे भेज देते थे कोर्ट में, और अगर नहीं एग्री होती तो डिवोर्स का मामला वैसे ही चलता था सर.
अच्छा, नहीं एग्री हो गए हैं और चार्जशीट फाइल हो गई, एक्यूज हस्बैंड ने बेल डाली है, तो फिर बेल तो उसका रिजेक्ट ही होना है कि बेल हो भी सकता है?
सर डोमेस्टिक वायलेंस के केस में
नहीं, इसे 498A और डाउरी प्रोहिबिशन का सेक्शन 3/4, डाउरी का भी एलिगेशन है और क्रुएल्टी का भी एलिगेशन है. तो मजिस्ट्रेट के कोर्ट में जाएगा और ये सारा मेडिएशन कंसिलिएशन जो है फेल कर गया, तो उस कंडीशन में क्या हस्बैंड को बेल मिलना चाहिए?
सर उसमें सर एक केस सर है अनिश कुमार वर्सेस स्टेट ऑफ बिहार. उसमें सर कुछ गाइडलाइंस दी हुई थी कि सर अगर ये 498A का सर केस आता है, या तो फिर ऐसा कुछ डोमेस्टिक वायलेंस का केस आता है, तो तुरंत ही उसमें अरेस्ट नहीं करते हैं. पहले सर उसमें कुछ प्रिलिमिनरी प्रोसीडिंग्स करते हैं, इंक्वायरी करते.
वो तो डिस्कस कर लिया आपने. मेरा क्वेश्चन ये है कि क्या उसमें बेल रिजेक्ट कर देना चाहिए हस्बैंड की?
नहीं सर, सर ऐसा सर रिजेक्ट नहीं कर सकते सर। बेल सर दे सकते हैं बेल उसमें।
दे भी सकते हैं और रिजेक्ट भी कर सकते हैं।
नहीं सर।
केस टू
हाँ
केस डिफर करना चाहिए ना
हाँ सर।
आप। ओके राइट। अच्छा, क्या ये 498A में ये जो क्रुएल्टी का एलिगेशन है, इसका रिलेशन डाउरी डिमांड से भी है?
हाँ सर है।
क्या प्रोविजन में डाउरी का कुछ है उसमें
सर
एलिमेंट?
हाँ सर। सर उसी सर 498A में सर सेकंड पॉइंट है कि harassed the other party or anyone related to her for the demand of dowry। सर वो है तो सर इंटररिलेशन तो बोथ आर इंटररिलेटेड।
आई थिंक डिमांड ऑफ डाउरी नहीं है उसमें, आप
सर
कंफर्म हैं?
सर डिमांड ऑफ डाउरी एकदम एग्जैक्टली वो टर्म नहीं लिखा हुआ है सर। मतलब कोई भी प्रॉपर्टी या वैल्यूएबल सिक्योरिटी डिलीवर करने के लिए या तो मनी देने के लिए सर उसके लिए हैरेस कर रहा हो तो या कोर्स कर रहा हो तो।
ओके, तो आप कंफर्म हैं, मान लिया जाए आपकी बात। शामली, आपकी बात मान ली जाए ना फाइनली?
सर 498 में ऐसा दिया तो है सर एज फार एज आई रिमेम्बर।
ओके, ठीक है शामली, तो आपकी जानकारी तो अच्छी है। अब देखते हैं पैनल में सर लोग और भी हैं, नहीं तो फिर आपसे बात होती है। क्या ओझा सर?
Sorry. Yeah. Sorry.
Sir, प्रणाम sir. Shambhavi, how are you?
सर आई एम फाइन।
All good?
थैंक यू सर। यस सर।
Just give me a moment. Okay. Tell me one thing. What protection would be available to people in live-in relationship on the same plane as married people get when it comes to domestic violence? So what protection will be available to the girl?
Sir, in that case, sir, in Domestic Violence Act, sir, the aggrieved person has been defined as any woman who is living in a shared household with the accused person. And sir, the shared household would not only mean persons relation related with marriage consanguinity, but it also means other relation which is resembling that of marriage. So, sir, in live-in relationships also, the girl will get protection. Also, sir, there is a case relating to it regarding Veluswamy versus Pechimal. Sir, in that case, it was said that the girl in living relationships, she will also get protection if domestic violence is committed against her.
That is one. Second, crucial example is of same-sex marriages. What will happen in that case?
Sir, in that case, if there are two boys, sir, in the aggrieved woman definition is gender specific. It only talks about women. So the boy will not get the protection.
Even though that particular boy may identify oneself as a female character, even then that person will not get the protection.
If that person identifies herself as a woman, sir, in that case, he should get.
Should get is okay. Yes, we are not clear as yet, but that is your proposition. But that's a very difficult proposition or situation, isn't it?
Yes, sir.
Because there is no official or legal way to ascertain as to which of the two actually identifies as a woman to get that protection. That is an issue. Okay, that's one. Second, tell me, have you ever gone through any report on judicial reforms?
Sir, I have not read as such, but I know reports of Malamet Committee and sir, the judicial advancement which has taken after that committee's recommendation.
And do you see that the inspiration of the three proposed bills, the proposed law that is there, does it have anything to do with the recommendations given by that committee? Is there anything that has been adopted and being tried to improve?
Sir, sir, I'm not sure about this thing.
Okay, as a judge, what are the small steps that you can take and make sure that the larger concerns about judiciary, at least at your level, those concerns are met and they are not perpetuated?
Sir, at my level, I think the biggest problem would be pendency of cases. Sir, at my level, I will, if I become a judge, sir, I will try that many adjournments are not given in the case, and when a judgment is pronounced, the decree shall be drawn as soon as possible. And also, sir, if there are persons who are from discriminated or backward section of the society, sir, I would try to get speedy remedy for them.
All right. Is it really proper to, as a judge, is it really proper to try to enforce the policy of affirmative action even in judicial proceedings by say favoring or giving precedence to the underprivileged? Are you entitled to that as a judge?
Sir, if I would do that, I would do it within the legal constraints. I would not go beyond what the law has prescribed. Sir, I believe that if we follow the procedure which has been given in the criminal procedure code or civil procedure code by the law which has been given, so then also change can be brought.
That's right. Have you heard about confession? Yes, you must
Yes.
have. Confession. And have you also heard about retraction? Retraction.
Retracted confession, yes, sir.
Yes. What is the evidentiary value of a retracted confession?
Sir, there is a recent case relating to it, Manoharan versus State, in which the Supreme Court has said that the retracted confessions, the value given to it would get diluted, and the court will become more cautious while dealing with retracted confessions.
On what grounds can a confession be retracted by the deponent?
Sir, so the person who has given the confession, he might say that he was it was not voluntary in nature, and he was forced by officials to give that confession. Sir,
Do you, if the cases of divorce they are increasing, is there any I'll not say outcome, but is there any positive sign also from within the society? If cases of divorce are increasing, what are the positive signs associated with it?
Sir, one positive sign would be earlier the institution of marriage was recognized through doctrine of curvature, in which the identity of women blends with the identity of man. So now women are so taking their individuality seriously, and if they feel that they are not able to cope up with that marriage, they can file divorce.
While replying to do you also believe that this increasing the increasing rate of divorce has also to do with the stigma that a stigma of divorce has also gone down? The prospects of women becoming independent, the prospects of asserting rights, that has also to do some do with it.
Yes, sir. That is also the case, sir. Earlier, sir, I would like to give an example, sir. Like earlier, in the cases of conjugal restitution of conjugal rights, sir, if the wife was working elsewhere, so this ground was not recognized and the husband was granted the restitution of conjugal rights. But now in 2017, sir, in one case Supreme Court has said that, sir, if wife is working at some other place, that it cannot be a ground for restitution. Sir, it cannot be said that she has abandoned or withdrawn from the consortium of marriage. So it cannot be a ground of divorce or restitution of conjugal rights.
You used a term while replying to one of the esteemed panel members. You used the word consanguinity. What is the meaning of that word, literal meaning?
So it means related by birth.
Then is it so? What is the meaning of the word sanguine?
Sir, sorry, I don't know the literal meaning of the word.
Blood. Sanguine means blood, related by blood. That is consanguinity. Okay. Have you heard about these two maxims, Aegisthum Generis and Nociter Soci?
Sir, so the first one would mean that if sir, I'm not able to phrase it properly, sir. If two, three, yes, sir. If 2-3 words of same nature has been given, and if the last word or the word which is following them is of general nature, then it can be presumed that it would be of nature similar to the words which is preceding it.
Okay. Let me give you an example and try to help me. Suppose law provide certain tax concessions to certain vehicles, and the language of law is like this: tax concessions shall be available to cars, trucks, lorries. Tax concessions are available to cars, trucks, lorries, and other motor powered vehicles. Fine. Now I'm asking, can a person who owns a ship, can he fit into it?
Sir,
so that you don't forget, is cars, trucks, and lorries, and other motor powered vehicles. Do you see that Aegisthum Generis can be applied here?
yes, sir. Sir, the vehicles which run on road,
Well,
sir, that would be considered as similar to the
exceptional. And what would be Nociter Soci?
Sir, I've not heard it properly.
It's not Nociter Soci, to be known by one's company, to be known by that you keep. That is the meaning of the maxim. That's fine. That's absolutely fine. Have you heard about liberal and strict? I was asking you, have you heard about liberal and strict interpretation of statutes?
Yes, sir.
When is liberal, this liberal interpretation of statutes is a presidential service, and when is strict?
Sir, in strict interpretation of law is done mostly in sir, where the concept of mens rea is of no importance, sir, in that case. And liberal interpretation is done in cases in which the objective is to look at the purpose behind which the particular enactment was given, sir. Then liberal interpretation is done.
Have you also heard about the phrase balance of convenience?
Yes, sir.
How is it applied? Where is it applied?
Sir, I've heard it in context of injunctions. when it is a principle that when injunction would be given or not. So balance of convenience in that case would mean, so the court should see both the parties, that whether injunction is given, what amount of loss will be caused to the other party, and if not given, whether the party seeking for it, he will get adequate compensation from money or not.
All right. What has been your favorite domain in the LLB course? What was the favorite domain, and who was the teacher?
Sir, my favorite teacher was Sir L.M. Singh, sir. He taught us Indian Penal Code. But my subject which I like is, sir, Indian Evidence Act.
Very well, very well. So currently, what is the position of affidavit? I'm asking again, affidavit. Can affidavit be admitted as an evidence in a court of law?
Sir, evidence. Affidavit can be accepted, sir. It has been mentioned under Order 19 of CPC, and also, sir, 295 and 296 sections of CRPC, which says that when evidence is of formal nature, then evidence on affidavit can be given. And also, sir, if evidence is given against a conduct of public authority, sir, in that case also evidence can be given through affidavits.
Yes, yes, absolutely right. Okay. So affidavit, this affidavit thing is a sworn statement, isn't it? It's a sworn statement. It binds the person who verifies it and deposes in the affidavit. What if the court is not ready to believe the contents of the affidavit? What are the ways by which it can be impeached? How to impeach an affidavit? Is it possible? It is just, gospel truth. It cannot be faulted with. Is it so that if somebody gives an affidavit, it cannot be faulted with? Or are there ways to find out the truth behind the affidavit?
Sir, it is not. So as you said, it is not a gospel truth. Sir, evidence can be asked for to rebut the statement which has been given in affidavit. Sir, through personal examination of the person which has given the affidavit. Sir,
absolutely right. Okay. Acha, evidence of hostile witness, does it have any value?
Sir, in that case, sir, if certain principle is applied, falsus in uno, falsus is omnibus. It means that if a statement is false for a particular instant, it cannot be accepted as false for the entire circumstances. Sir, hostile witness can be accepted if to some other facts. It means it can be accepted.
Absolutely right. Absolutely perfect. Final question from my side is presumption versus fiction. If you could give an example and differentiate the two. Presumption versus fiction.
Fiction.
Yes.
So presumption would mean certain inferences which we draw from proved facts or admissions, or certain facts which the court should take judicial notice of. And friction, sir, it would mean it is
not friction, fiction. Statutory fiction. Yes, legal fiction.
Legal
deemed
fiction.
to be. Deemed to be.
Okay, sir.
What is the difference between presumed to be and deemed to be?
Sir, deemed to be, it means that sir, I would say that a statutory fiction is, so if a certain thing is said that it will be deemed for like deemed decree, so then it is possible that the particular thing would not fulfill all the criteria which is relating to that the certain thing would be called a decree, but still it would be presumed that, or it would be deemed that it is.
Deemed, that's the difference. To presume and to deem. What is the main difference? Can you think about it? Take 10 seconds.
Sir, I think that presumptions are based upon certain proved facts or certain which is general in nature. But
If it is proved fact, then it will not be presumed, na. Presumption, the role of presumption comes only when there is no fact to be proved.
sir, I meant to say that inferences which we draw from certain proved facts or certain admissions, that is presumption. But sir, I'm not able
Presumption,
to. Yes,
koi
sir.
baat nahi, koi baat nahi. Presumption is rebuttable, fiction is not. As simple as that. Once the statute or the court deems something to be, it cannot be rebutted. It's deemed. But what is presumed, that can be rebutted by the other party by leading evidence, isn't it? That's how. Very well. And as I said last time also, you are doing very well. I am very contented with your performance. We'll get back in the feedback session.
Yeah, Shambhavi,
Yes,
there is
sir.
a lot debate in the basic structure of the Constitution. The main reason why I want to understand from you, 2 CGI has a different opinion. Rajan Gogoi and Dhananjay Chanchol. Why they have the different opinions? What they are saying?
Regarding basic structure.
Yeah. You must have read in the newspaper. This debate is going on last more than 1 month.
Yes, sir. Sir, our Honorable Chief Justice has also called basic structure as a North Star which guides us interpreting all the other laws which emanates from various statutes. And sir, the other justice, sir, he said that the judges of Supreme Court said they are taking basic structure as a defense to negate certain principles which they do not believe in.
Fundamental duties, basic structure or not?
So fundamental duties, sir. So it is basic structure of the Constitution because in the case of Naveen Jindal versus Union of India, it was said that the fundamental duty is, sir, it emanates from the fundamental rights itself. And if certain person he do not follow the fundamental duties, then he cannot come before the court that his fundamental rights are breached and to enforce such rights.
Fundamental duty came into existence in 1976 by 42nd Amendment.
Yes, sir.
It means basic structure has been rectified in 1976. Prior to that, fundamental duty was not in the Constitution. So therefore, the basic structure prior to 1976 and post 1976 has 2 scenarios. Yes or no?
Sir, can you please repeat the question, sir? The voice is not.
Basic duties came into the Constitution in 1976 via 42nd Amendment. Therefore, the basic structure prior to 1976 and post 76 has 2 scenarios.
Yes, sir. It can be said.
Then it means the basic structure is not sacrosanct.
Sir,
Think for a moment.
the basic structure. Sorry, sir, I'm not able to.
No issue. NJC has violated the basic structure. It is being said by the Supreme Court. One of the Chief Justice has said that NJC is not violating basic structure. Do you know who was the judge?
No, sir. Sorry, I don't remember the name.
Yeah. Basic structure doctrine was passed by the very marginal minority. 7-6. 6% was against the basic structure, 7 was in favor of the basic structure. 11 judges has written the separate orders on that. How you can say that such a divergent opinion order and passed by a only thin margin has the sacrosanct of the basic has sacrosanct?
Sir, sir, I think that the basic structure, sir, it involves all those principles which are important for the constitution, sir, through which all the other right emanates. Sir, it is so basic.
You are not. You're not answering what I framed the question. Should I explain again the question? The basic structure doctrine was passed by majority of 7-6. 6 was against it, 7 was in favor of this. 11 judges has written the separate orders. It itself is saying that there's a lot divergent opinion on the basic structure. How you can say that it is the sacrosanct?
So that what I was saying, that sir, so I don't think that opinion that from 6 judges were opposing it. For that reason, it cannot be said that it is not sacrosanct, because it contains the basic principles which the constitution provides. So that is considered as the basic structure of the constitution.
You have heard about the disclosure of the assets and liabilities by the government servants?
Yes, sir.
Judiciary also doing this?
Sir, I am not aware. So sorry, sir.
Judiciary is not doing it. It is not compulsory, it's voluntary. Is it fair?
Sir, in my opinion, sir, all the public authorities, sir, they should disclose their assets. So
You are in favor that judiciary should disclose. Judiciary should also follow the line to disclose the assets before the public authority, before the public.
yes, sir.
But judiciary is not doing this. Judiciary is at fault.
Sir, sir, I think that all the organs of the sir government, whether it be judiciary or executive, sir, they are responsible towards the people of the country. So I think that the judiciary should also disclose, and there should be no distinction between executive and judiciary for that matter.
You have answered one of the question of the divorce. You are a judge. Divorce cases are coming in front of you. What will you do? You will prefer the reconciliation, or you prefer for the divorce?
Sir, I would prefer reconciliation, sir, because sir,
Why reconciliation? Is it your job to reconcile?
no, sir. Sir, sir, I would see the fact. It may differ fact to fact. If I feel seeing or hearing the parties that reconciliation could be done, sir, I would send them for mediation, and I would give
Is
them.
there any provision which are suggesting you to go for to work on this, the reconciliation? You are bound by the question put before you. You are bound by the question of law, question of facts put before you. You can decide on that. What is the concern of the reconciliation? Why you want to do this? You are not there to change the society. You are there to deliver the justice. The girl has approached your court for the divorce. She said, I want to have a divorce. Why you work for the reconciliation? You are not exceeding your domain.
Sir, in the divorce cases also, so 6-month cooling period is given for that purpose only, that reconciliation, if possible, could be done between the parties. So, sir,
Can you go beyond the question posed before you for the adjudication?
Sir, if so I don't think asking the parties for reconciliation would go beyond the power given to me.
As I understand, you are bound by the matter put before you. You may suggest to the council that you go for reconciliation. They say, no, I don't want. Then what will do? Thank you, Shambhavi. You have done exceedingly well. My opinion is reaffirmed for you. What Shaur has said, I'm totally in agreement with you. You are unbeatable on the law.
Thank you.
Me and Shaur has definitely taken the different interviews. We have felt that we tried to catch on certain issues. I'm posing one or two articles on the basic structure. It's very unfortunate that the basic structure doctrine is not completely understood by most of you. It's very unfortunate. You should and this question is very because the two CGI has a divergent opinion. Rajan Gogoi has told in the Rajya Sabha, which has been countered by the Dhananjay Chandrachud sir. After that, a lot of debate is going on. And it's very important part that post-Nuri was not aware. It was 7-6. 7-6 is nothing. It's a marginal victory. 11 judgment has been written. This itself shows that your answer about the fundamental duty is an amazing answer. Let me take you some of the issues. As far as the law is concerned, I don't think you have any issue. For the reason of the divorce increase, I think you should have gone some sociological aspect also. Don't confine yourself only with the law only. If you want to score the more answer, you need to have the more beyond the law. The question has been asked: the reason for divorce increased, and it is giving the acceptability to the society. We have gone on the again. You started answering the law. The question was not with respect to law. Law was immaterial here. So I think that you avoid. एक आप बोलते हो बीच में उसको आप कंट्रोल करने की कोशिश करना. मेरे ख्याल से बाकी तो कोई मुझे दिक्कत नहीं लग रही. I don't want to take anything you. जुडिशियल रिफॉर्म में आप एक आध आपको आना चाहिए. शौर्य ने सवाल किया था, एक आध को आप तैयार रखना चाहिए था. पॉलिसी ऑफ अफर्मेटिव एक्शन, ये भी सवाल थोड़ा बेसिक हो सकता था. आपने आंसर किया, but it has been a bit better answer. I think interpretation statute शौर्य लगातार पूछ रहे हैं, but I still think कि interpretation statute आंसर थोड़ा बेहतर होना चाहिए था. Affirmative answer का अच्छा था. Anyhow, I'm just trying to take a critical view. That's trying to point out some matters. Overall, I'm very satisfied with your answers. I have no issue. You will be certainly selected. That's all. Yes, sir.
Thank you, sir.
Yes, sir, my impression is also the same. I will be only disappointed if she is not in the top 5. So that will be the only shock. You cannot surprise us by your selection. You can only shock us. That's what it is. That's one. But there are some small things. I think you should always be cautious, right? Since the first question till the last question asked by the panel there, you should be very cautious that you do not take any stand which is casual. टेक्निकली कॉशियस रहो, तुम टेक्निकली कॉशियस रहो और रोबोटिक टाइप का माइंड रखो. रोबोटिक आई शुड नॉट से, very systematic. So if sir is asking, two disputing people or conflicting people are coming to you, the couple is coming to you, what would you do? Then what you said subsequently should have been your first answer. Okay, sir, that would vary greatly on facts and circumstances of each case. If I find that the benefits of allowing time for reconciliation, they outweigh the risks, then I will definitely go for it. I consider it a better option. But there are situations where threat to life and threat to dignity is much higher. In those cases, sir, better divorce might be a better option. Might very well be a better option depending on the facts. So पहले ही ले लीजिए आप, पहले ही technically correct stand लीजिए. That's not your job. If they are coming to you, you go as per law. And if you have to choose between reconciliation and this, then you have to weigh each and every case. It cannot be universal, case to case. It has to be. So that is the best answer, to say case to case. And otherwise, your answers are very good. I will not ask you to study anything, nothing. Just think and try to give short answers. This time, I am very satisfied. Your answers are very succinct. That's wonderful. So you have improved upon that. That is also taken care of. Keep yourself well, I mean, in the good physical and mental health. Do not, beyond a point, realize that beyond a point, this point I will not argue. No, I will not argue. 1, 2, maximum 3 questions and answers. Thereafter, you withdraw very respectfully. Sir, I might be requiring more study on this. I'll not treat myself competent to answer this right now. I think this is a new dimension to my thought, and I think I need to study on this. Best, do not engage into any conflict, and that's it. You are doing perfectly fine. You'll do very well wherever you are. All the
तो
best.
अभी जो सवाल था डाइवोर्स का, you can answer this also कि sir, on the basis of the facts of the case, I may conclude that, or I may observe that whether the reconciliation is possible or not. If possible, I will go ahead. जो शॉर्ट ने कहा ना फैक्ट्स ऑफ द केस, वो आपका सवाल ठीक था, शुरू होना चाहिए. दूसरा, जो सवाल का आंसर आप नहीं दे पाए, वो आपके लिए आसान था भी नहीं, क्योंकि पर्पसली वी वांटेड टू हैव द रफ ऑटो टुडे. दूसरा क्या है कि आप जैसे आपने एक में क्लू मांगा था, हमको क्यों क्लू मत मांगो आप. डोंट आस्क द क्लू कि शायद इनका सवाल था, कहते हैं अनुज जी का, आपने क्लू मांग लिया था, तो क्लू मत मांगो आप, कोई पर्पस नहीं क्लू मांगने का. बाकी आप क्या करो, देखो 2 काम करना, आप पानी पीना, वॉशरूम को यूज करना, जो 2 बहुत इंपॉर्टेंट चीज है. उससे क्या है, आपका माइंड सेफ रहेगा. पढ़ने की कोई जरूरत नहीं है. नथिंग यू रीड, नॉट ए सिंगल लाइन यू रीड. यू गो विद द कॉन्फिडेंस. आई एम 100% श्योर यू विल सिलेक्टेड. चलो, थैंक यू. आकांक्षा.
ओझा जी,
हाँ.
ये मैं भी ये देख रहा हूँ कि इनकी तैयारी बहुत अच्छा है, प्रेजेंटेशन बहुत अच्छा है. बस जरा सा इनकी अपनी ओपिनियन जब पूछी जाए तो अपनी ओपिनियन से शुरू करें, सीधे उस पर ला पे ना. भाई जैसे सोसाइटी में डाइवोर्स भाई इतनी देरी से हो रहे हैं, इसके क्या रीजंस हैं? तो इसमें अपने जो सोसाइटी में जो दिख रहा है वो सारे रीजंस 1 by 1 प्रायोरिटी के हिसाब से बताना चाहिए. तो वो थोड़ा वहां हेजिटेट
इसको जाने दे, इसकी ट्रेन जैसा सी ट्रेन इसको जाने देते हैं. ठीक है ना, चलो, ओके.
ठीक है.
आकांक्षा कम. ये आकांक्षा कम.
Yes, sir. Good evening.
हाउ आर यू?
Fine, sir. Thank you.
Akanksha, tell me something about yourself.
Sir, my name is Akanksha Devi. I am from Prayagraj. I have done my schooling from Jawahar Navodaya Vidyalaya, Fatehpur. I have completed my graduation and post-graduation from Banaras Hill University. Currently, I am living.
Why you gone to BHU?
Sir, to do LLB, to complete my graduation from this.
Why you choosing BHU, not any other university?
Because sir, I had heard that BHU is better, and on the basis of ranking also, the law school is better there.
Are you satisfied with your decision, your judgment?
Yes, sir. I am very satisfied.
Akanksha, you have heard one of the discussion with your previous colleague, Mr. Shambhavi, about the basic structure. You may have got some idea about the basic structure. Why basic structure should not be done away? What is needed? What is point?
Because sir, there are certain things which should always be there to protect rights, to protect the rights and liberties of people, and to protect the fundamental rights, and to establish the freedom and liberty and like judiciary authority.
Do you think without without basic structure, you cannot defend these things which you are saying?
Sir, we can defend these things without them also, but sir, in the presence of basic structure, that thing can be made assured in a very well way.
How can I assure? Tell me. It is not assuring. If you see the case of the Delhi, first, Parliament has made the law. Supreme Court has overruled it. They again made a law.
Yes.
Where is the safety? It's an example in front of you, which is countering your viewpoint, which you are just suggesting to us. You thought this? Come on, the second problem of the basic structure. You are talking for the center and state. What about the local bodies? If federal structure is between center and state, why not with state and local bodies? As already said, the basic structure doctrine is a very marginal victory. where there is a divergent opinion and still a lot of debate, why we are sticking up upon it? What's the reason? Tell me. Just think for a moment.
Sir, can you please repeat the question? I'm not getting the question.
The basic structure doctrine is under debate.
Yes.
There is only marginal victory in favor of the doctrine. 7 to 6. 11 judges has written the judgment. This fact itself saying that there is no unanimous opinion in the judiciary and only marginal opinion in favor of it. Why we are sticking upon it? Why we should not change it?
Because sir, there is no better way than going up with the majority's view. And sir, it has
Think more.
always been accepted.
Think more. It is the limit set by the judiciary.
Yes, sir.
Can judiciary control everything? Parliament cannot do anything. Why
No, sir,
judiciary in the 70s, judiciary has made a policy controlling the parliament. 40 years has been passed. A lot of dynamics in the society has been changed. Why a order of 40 years back should dictate us? Just think. Have you read the data protection bill?
yes, sir.
In the data protection bill, the government is out of the purview. You must have read it. Why it is? Why it is? Why government is not under the data protection? What's the reason?
Sorry, sir.
Religion is part of the life. Yes? Can the constitution control it?
The constitution can control it in a positive way.
Not negative way.
Yes, sir.
Tell
Because
me,
of
tell me, I got one. Tell me how the constitution is protecting in the positive way.
Sir, by providing the rights relating to religion, like
Okay.
for example, yes,
Okay. Why we need democracy? What is the importance? Why we need democracy?
to establish a government which is selected by the people of.
You want to say democracy is required because we need the governed by the people.
Yes.
The people should decide.
Yes.
You want to say this, no? Why should people decide?
Because sir, it is them on whom the rule will be done. The government shall be ruling over the people. That is why people should select the government. People should select the person.
I got your answer. Let me reframe your answer. You want to say that the aspirations of the people is very important. That's why people needs to select government. This you want to say?
Yes.
But does by selecting the government by the people, aspiration is being satisfied?
Not by just selecting the government, but by some policies which the government implies on the people.
We heard that there is a integrated judicial system. What is this? In India, it's being said that it is a integrated judicial system. What is this? Integrated judicial system.
So subordinate courts are being guided by the superior courts, and so the independence of judiciary is ensured.
Again, you said integrated judicial system. Does it not mean the order passed by the higher courts are binding on the lower courts?
Yes.
You have said the answer, but exact wording was missing. What is minorities and marginalization?
So minorities basically is concerned with the number of comparison with the majority. And sir, other term you used was
Marginalization.
marginalization. The people who are marginalized in a negative way. That is people who are not on equal representation.
Okay. Thank you. Sorry.
Ji sir, ji sir. Sir. How do you see implementation of laws? How laws would have been administered and implemented when there was no democracy? Democracy is how many years old? As an experiment in the society, how many years do you think democracy is old? Which is the oldest democracy? And 200 years, 300 years? Before that, and for India, for example, for our country, democracy is how much older than other? That's all, isn't it? For the rest of the period in history, it was not democracy. Or was it? Are there any instances, any examples of democracy from ancient India?
Yes, sir. Sir, as far as sir, I remember, sir, in Harappan culture, there was democracy.
Okay. Any specific instance you remember?
Sir, I cannot recall it, sir. I have read it, but I'm unable to.
Have you heard about Mahajanpadas?
Yes, sir. Mahajanpadas.
Did they have democracy or were they only republic?
Sir, I think the democracy was there.
Okay. Okay, so what is the best thing about democracy today? What is the best thing for you as a citizen? Tell me.
So my rights are ensured in democracy, and the government which is rolling over me is selected by me. Basically, sir, my representatives are there in government body. This is the best thing.
And that is the best part about democracy. That
Yes, sir.
yes, your will, as they say, the will of the people is reflected.
Yes.
Isn't it? Okay. Do you think that for a setup like India, separation of powers, strict separation of powers is good, or is it not practical?
So there is separation of powers, but sir, in my opinion, the strict separation of powers is not there, and sir, because provisions like checks and balances are there, and sometimes also one body over imposed its policies over another body.
And is that good?
Yes, sir. I think it is good, sir.
So judicial act,
As
nothing
for
wrong
us,
with
it is
judicial
not.
activism.
Sorry, sir.
There is nothing wrong with judicial activism and judicial overreach.
Sir, judicial activism is fine, but sir, judicial overreach cannot be said to be good.
All right, all right. Do you also see a situation where for making a law, it may be actually not possible to take the channel of legislature and Supreme Court may have to step in? It may be incorrect or it may be not preferable or advisable, but are there situations where the country cannot wait for the legislature to get people's will and then legislate, and that is why an immediate intervention of judiciary is required? Do you remember any such instance? Has there been have there been cases like that?
Yes, sir. Sir, for instance, the Sabrimala case.
Okay.
In that, yes, sir. So in that case, the women were not allowed in the temple, and sir, judiciary, uh, by judicial activism, courts allowed the entry of women and it was an example of judicial activism where the law was not there like that, but judiciary intervened in a good way.
So was Sabrimala about entry of women in the temple?
The entry of women from age 10 to 60-year-old.
All right, all right. Are there also certain temples where entry of men is prohibited?
Sir, I have heard about some of temples.
Okay, that's fine, that's fine. Tell me about Indian Evidence Act. Whatever provisions of Indian Evidence Act they lay down, whatever they lay down, is that substantive or is procedural?
So basically, it is substantive, but in many cases, court has opined that this is substantive as well as procedural. For some part of it is procedural.
Okay, so are the courts bound to follow the Indian Evidence Act strictly?
Sir, Indian evidence, sir, courts are bound to follow, but sir, in some cases, like in cases of affidavit, the Indian Evidence Act shall not be applicable.
That's fine. Your answer is correct. The first part of your answer is correct. That court has to strictly follow the Indian Evidence Act. Is there any other judicial or quasi-judicial process where Indian Evidence Act may not be followed strictly? Any other place where justice is delivered?
Sir, in arbitration procedure.
And tribunals?
Yes, sir.
And tribunals as well, isn't it? So, what do you say? Do tribunals have the power to punish for their contempt?
Sorry, sir.
You're not out. Okay, fine. How do you see the representation of women in judiciary? How much is it? A rough estimate.
Sir, there has been improvement in number of women participation in judiciary, but there is still room for improvement. And sir, talking about the numbers, sir, in higher judiciary it is 15%, and in the subordinate court it is 30% of total number of judges. And sir, also in the number of women in bar is out of 1.5 million. I think, sir, it is only a very few percentage of women is there.
Right, that's fine. That's fine. You made your point. So the Supreme Court is the highest court of the land, and then there are high courts. Are the high courts subordinate to Supreme Court or not?
Yes, sir, they are subordinate.
Are they subordinate in the judicial sense or only the administrative sense? Or both?
Sir, both.
Okay. So the court that you would be chairing, does that court have the power to contempt for its punishment?
No, sir. Sir, it cannot punish for the contempt, but sir, it can communicate the matter to the higher court.
And why can't it punish for its contempt?
Because sir, this power has only been provided to Supreme Court and High Court.
And why? Because they are what? They are courts of record.
They are higher. Yes, sir.
Because they are courts of record, that is what it is called. So what is a court of record?
Sir, a court of record where the all the judgments and orders of such court shall be followed by subordinate courts, and the court shall be empowered to punish for its contempt. That is why they are court of record.
Right. Unless they are recorded, who would check that the decision was followed or not? Isn't it? It's very logical. They have to be a part of the record, then only somebody can check whether the decision was followed or not. So that is why they are preserved as a matter of perpetual record for posterity, so that because they have binding nature. So that is why. So you must have heard about the terms ratio decidendi and obiter dictum.
Yes, sir.
What is it about this obiter dictum thing? Is it binding?
No, sir. Sir, it is only opinion of the judges. It is not binding.
does it matter as to which court has actually given that opinion? Does it vary from court to court, or all obiter dicta are not binding?
Sir, in my opinion, sir, all the obiter dictas are not binding. These are just opinions.
All
which
right.
are just provided in our
Does Supreme Court's obiter dictum has higher weightage than other courts? Has something like that been done or said?
Yes, sir, I think so.
Okay. You must have heard about this maxim stare decisis. So this stare decisis versus res judicata. What is the difference between the two?
Just a
Can you
moment.
start with telling one by one what is a stare decisis and what is res judicata?
The res judicata is basically the matter which already has been decided by any court. And sir, stare decisis is under Article 141, where the subordinate judges have to follow the judgments orders pronounced by the Supreme Court. All the judgments shall be binding upon the subordinate courts. All the judgments of Supreme Court shall be binding.
Does it also matter as to what was the strength of the bench that decided the case?
Sir, it doesn't matter for subordinate courts. But sir, if a matter has been overruled by a higher bench, then sir, that decision should be followed by
If
the law.
two benches of the same court have a differing opinion, one was 10 years ago and the second opinion is being now made today, and they have conflicting views, but their strength is the same. Which opinion will hold?
So the latest opinion will be matters will hold.
Okay. You have heard about this constitution bench thing.
Yes.
Okay. So just name the benches according to their strength, starting from low to high. How do we go about it? What is that bench called where there is only single judge? What is the name of that bench?
Single judge bench, I cannot recall the name.
Okay. If it has two judges, then what is the name of the bench that has two judges?
The constitutional bench.
Two judges is not constitutional. No.
So 5 or more.
So what is division bench? Tell me. What's a division bench? Because there is a possibility of division. ऐसे याद कर लो. Because there are two. Okay. So 3 or more हो जाए तो फिर क्या हो जाएगा? Constitutional होगा, या 5 or more होगा तब constitutional होगा?
So 5 or more constitutional bench.
Okay. You must have heard about circuit bench. Have you heard about this term, circuit?
So I have heard, but
Acha, tell me, administrative law in this country is governed by statutes or by bylaws? For example, laws related to those civil servants, us, public authorities, bureaucrats.
by the statutes.
By a statute, okay. So these conduct rules which are there, they have the force of law.
Yes.
Okay. Tell me, which is your favorite judgment and why?
Sir, there are many judgments which I like, but sir, in latest judgments, the one is Sabrimala judgment and sir, adultery, whereby adultery was decriminalized. So these two are my favorite for now.
Okay, fine. So adultery is no more a crime, is it so?
Yes.
Does it adultery has some gender orientation, or adultery by anybody is not a crime?
Sir,
Male or
under identity, it was adultery by the man was an offense, and in the judgment, Supreme Court has uh, decided that the adultery will not be a crime because it was a gender-oriented uh, offense, whereby the women were not given the women were treated like the property of husband, and she was not given many rights because of that. And sir, it was the violation of some fundamental rights like Article 14 and 19.
Very well, very well. That will be all from my side, and we will get back in the feedback.
जयसवाल जी।
जी, आकांक्षा,
Yes, sir.
आप क्या तैयार करके आई हैं?
Sir, Indian Evidence Act. So all of subjects mostly sir,
ये
Indian Evidence.
इंडियन एविडेंस एक्ट और
Sir, IPC.
IPC, बाकी भी तो पढ़ा होगा।
तो सारे पढ़े हुए हैं सर, भी कॉन्स्टिट्यूशन थोड़ा सा कम था यार।
ओके, आकांक्षा, स्टॉकिंग क्या है?
So stalking is whereby a male person is contacting or trying to contact a woman again and again despite of her expressed rejection, and also the monitoring of computer activity or such online activities by the woman. Monitoring of such activities. This is stalking.
अच्छा, एक टैक्सी स्टैंड पे एक लेडी अपनी जर्नी स्टार्ट करती है, पास में ही कोई मेल पर्सन खड़ा है, उसकी तरफ देखता है और वो भी उसी टैक्सी में बैठ जाता है। फिर टैक्सी जाके दूसरे किसी प्लेस पे वो फीमेल छोड़ देती है, फिर आगे जर्नी स्टार्ट करती है, फिर देन अगेन उस पे वो बैठा हुआ, और ये 2-3 दिन से चला रहा है।
Yes.
ऐसा ही होता है, और वो आदमी उससे कुछ भी कहता नहीं है। तो इस केस में क्या होगा? आपके पॉइंट ऑफ व्यू क्या है आपका? क्या ये स्टार्टिंग का ऑफेंस होगा?
No, sir.
जी,
Sir, no, sir. It will not be an offense of stalking under IPC.
ओके। और यदि वो उसको लगातार घूरता रहता है और जर्नी भी करता रहता है पीछे पीछे, तब
Then, sir, it can come under this stalking unless the male person proves certain exceptions which are given under 354D.
स्टॉकिंग का प्रोविजन आईपीसी में ओरिजिनल है या बाद में कुछ किया गया है?
So it was not original; it was added by the amendment.
कहाँ प्रोविजन है इसका?
354D.
ओके, राइट। इधर विमेन्स को प्रोटेक्ट करने के लिए, एविडेंस देने के लिए काफी सारे एक्ट बनाए गए हैं, अमेंडमेंट किए गए थे। कुछ दो चार आप बताएंगे?
Sir, acts or provisions.
जी,
Sir, there are many acts like Indecent Representation of Women Act, Dowry Prohibition Act, Protection of Women from Domestic Violence Act, and
ओके। ये डोमेस्टिक वायलेंस एक्ट में क्या एफआईआर होती है या कंप्लेंट फाइल होता है?
the complaint file होती है।
कंप्लेंट फाइल। क्या एक साथ एफआईआर और कंप्लेंट दोनों हो सकती है?
No, sir.
नहीं हो सकती। कोई बार है इसमें?
Sir, the aggrieved person has to choose one remedy. Whether she can
आजकल तो देखने में, आजकल तो हस्बैंड वाइफ में जब भी डिस्प्यूट हो रहा है, सबसे पहला काम एफआईआर लिखा दो, दूसरा काम डोमेस्टिक वायलेंस में भी कंप्लेंट फाइल कर दो। तो आप कंफर्म है कि दोनों में से एक ही चलेगा?
यस सर, एक ही चलेगा, क्योंकि अगर दोनों चलेगा तो सर डबल जीओ पार्टी वाला प्रोविजन आ जाएगा।
डबल जो पार्टी की थियरी क्या है?
Sir, under Article 20, Clause 2, a person cannot be convicted or tried for the same offense twice.
आई थिंक उसमें है प्रोसिक्यूटेड एंड कन्विक्टेड। प्रोसिक्यूटेड एंड कन्विक्टेड में प्रोसिक्यूशन पे कोई बात तो है नहीं। यदि वो कन्विक्ट हुआ हो तब बात होगी। इस केस में क्या होगा? यदि प्रोविजन ये है कि प्रोसिक्यूटेड एंड कन्विक्टेड,
Yes, sir.
तो
Prosecuted and convicted.
डबल जी।
Yes, sir. Prosecuted and convicted is there under Article 20.
तो फिर इसके हिसाब से बात तो नहीं है अभी।
But sir, I think only one remedy can be exhausted.
ओके, अच्छा, कंप्लेंट का क्या मीनिंग है?
Sir, under Section 2, Clause D, complaint has been decided. Has been described.
ओके, क्या पुलिस ऑफिसर भी कंप्लेनेंट हो सकता है?
Yes, sir. Sir, when the case is non-cognizable offense, then the report of police officer shall be considered as a complaint.
ओके, अच्छा, ये पुलिस थाने में एफआईआर नहीं लिखी जा रही है, तो जो विक्टिम है उसको क्या क्या रेमेडी है विद इन द परव्यू ऑफ लॉ?
So firstly, he can go to superintendent of police, and even then, if the FIR is not being registered, then he can go to the magistrate
अंडर विच सेक्शन?
under 156.
1 2 3?
Sir, sir, I am unable to recall the section.
ओके, बहुत पॉपुलर है 156 3, 156 3 के नाम से बड़ा मशहूर है आपके जो भी स्टूडेंट हैं उनके बीच में। अच्छा, ये मजिस्ट्रेट उसमें वह 156 3 में एफआईआर रजिस्टर करने का ऑर्डर करता, राइट?
Yes, sir.
तो क्या मजिस्ट्रेट के पास कोई और कहीं पे ऐसा पावर है कि वो पुलिस को इन्वेस्टिगेट करने का ऑर्डर कर सकता है?
Yes, sir. Sir, in
कहाँ है?
all the cases, the magistrate is empowered uh, uh, issue the warrant. He can order the police officer to start the investigation.
आप रिपीट करें आंसर को, थोड़ा क्लियर
Sir,
करिए।
in all the cases where the magistrate is empowered to issue the warrant for the arrest, and
ये आप कहना ये चाहती हैं कि यदि मजिस्ट्रेट को जिस मजिस्ट्रेट को वारंट इशू करने का पावर है वो इन्वेस्टिगेट करने का भी ऑर्डर कर सकता है, राइट? तो मजिस्ट्रेट तो एक विटनेस को अगेंस्ट में भी वारंट इशू कर सकता है अंडर सेक्शन 82 83 के आसपास के जो भी प्रोविजन है। तो किसी को सम्मन कर सकता है, सम्मन नहीं आता है तो देन वीडब्ल्यू कर सकता है, फिर देन वीडब्ल्यू के बाद भी नहीं आता है तो एनवीडब्ल्यू कर सकता है। तो उनके मामले में भी इन्वेस्टिगेशन का ऑर्डर कर सकता है।
no, sir.
आपकी बात को मान ले तो
Sir, I'm unable to recall the provisions right now.
ओके।
I'm forgetting this.
ओके, कंप्लेंट केसेस में इन्वेस्टिगेशन का ऑर्डर करता है, इसमें एक जगह प्रोविजन है, वो आपके ध्यान में है? सेक्शन 202 में है मजिस्ट्रेट खुद इंक्वायरी करता है या उसमें इन्वेस्टिगेट करने का रहता है। ठीक है, एविडेंस आपका जो है फेवरेट सब्जेक्ट है, और ये बात कई बार पूछी भी जा चुकी है कि एफिडेविट को क्या एविडेंस एक्ट एविडेंस की कैटेगरी में रखता है?
No, sir.
तो क्या किसी भी सूरत में ऑन एफिडेविट जो चीजें दी जाती है उसको एविडेंस ट्रीट नहीं किया जा सकता?
Sir, not under Evidence Act because sir, it is not made on oath.
ओके, 165 क्या है एविडेंस एक्ट का?
Sir, under Section 165, a judge can, for the interest of justice, a judge can call for any witness or document, and sir, he can also
Okay.
ask any question, yes, sir, within the limitations given under Evidence Act.
ओके ओके, ये प्रिविलेज कम्युनिकेशन देने के पीछे का क्या कॉन्सेप्ट है?
So, to protect the privacy of citizens, and for example, sir, in case of husband-wife relationship, it is for to protect the privacy. And sir, in case of advocate-client relationship, professional communication, so to ensure the trust or faith of client in the advocate, so that the
ओके,
justice
अच्छा,
can be used.
एक जज साहब जो है अपने डायस पे बैठे हुए हैं और एक एक्यूज वहां पे लॉकअप में है, कोर्ट रूम में। कुछ एडवोकेट्स आते हैं और उस एक्यूज को पकड़ के कोर्ट रूम में ही पीटना शुरू कर देते हैं और घसीटते हुए लेते जाते हैं। इस केस में क्या जज साहब को एज ए विटनेस किसी मैटर में कॉल किया जा सकता है?
Yes, sir.
कहाँ है प्रोविजन?
So section 123.
123 ये 123 है, 123 में कुछ 120 तो कुछ हस्बैंड वाइफ से रिलेटेड।
So 123 husband-wife to related. 120.
ओके, आकांक्षा,
Yes, sir.
एविडेंस एक्ट केवल क्रिमिनल लॉ पे एप्लीकेबल है?
Sorry, sir.
एविडेंस एक्ट जो है केवल क्रिमिनल लॉ पे ही एप्लीकेबल है?
No, sir. Sir, civil laws पे applicable is.
आर्बिट्रेशन एक्ट पे, आर्बिट्रेशन के मैटर में?
No, sir.
आपकी आवाज साफ नहीं आ रही है।
Sir,
तो
no, sir.
आवाज आ रही है?
Okay.
एकदम साफ आ रही है, एकदम साफ आ रही है,
अच्छा, आ रही है।
एकदम साफ आ रही है।
अच्छा,
अच्छा अच्छा बोल रही है, एकदम साफ आ रही है।
हाँ, अच्छा, नहीं मुझे थोड़ी सी पता नहीं क्यों जो है साफ नहीं आ रही है। ओके, नहीं ठीक है। ये लीडिंग क्वेश्चन जो है ये चीफ एग्जामिनेशन में क्यों पूछने का परमिशन नहीं है?
Because sir, leading question are some such type of questions in which the person who is asking is expecting the exact answer, one like direct answer. Sir, in chief examination, such questions are not allowed because uh, in
नहीं,
examination
वो तो सही है, ये भाई सेक्शन 141 कहता है तो उसमें कि भाई चीफ एग्जामिनेशन में ये अलाउ है, ये बात तो सही है, लेकिन मैं ये कह रहा हूं कि चीफ एग्जामिनेशन में अलाउ क्यों नहीं किया जाता है?
because sir, the person calling a witness cannot directly ask someone like, for example, have you committed murder? The answer is sir, basically in yes or no. That's why sir, they are prohibited.
ओके, री एग्जामिनेशन में लीडिंग क्वेश्चन आस्क किया जा सकता है?
Yes, sir.
किया जा
With the
सकता है।
permission of court. Yes, sir.
तो विद द परमिशन ऑफ कोर्ट तो चीफ एग्जामिनेशन में भी पास किया जा सकता है।
Sir, under the provisions
दोनों तो
that sir, leading question can be asked in cross examination and re-examination. But sir, for examination in
देखिए लीडिंग क्वेश्चन के 3 सेक्शन है, 141, 142, 143। ठीक है, लीडिंग क्वेश्चन डिफाइन कर दिया 141 में, 142 में कहा क्रॉस एग्जामिनेशन में पूछे जा सकते हैं, 143 में कहा गया कि चीफ एग्जामिनेशन और री एग्जामिनेशन के बारे में बताया गया है। तो वो तो दोनों का सेम पुटिंग है, चीफ एग्जामिनेशन और री एग्जामिनेशन दोनों में या तो पूछने की लिबर्टी है या नहीं है, और है तो कैसे है, कोर्ट के परमिशन से आपने बताया, तो दोनों में है ना। ओके, ठीक है आकांक्षा जी, नेक्स्ट ओझा सर।
या चित्रेश
जी सर।
जो भैया
सर अनुज सर है, अगर 5 मिनट पूछ ले तो मैं 5 मिनट में घर पहुंच जाऊंगा, गाड़ी से फिर ये डिस्टरबेंस रहता है, तो 5 मिनट बाद में
ठीक है।
去年的爸爸，去年的爸爸，去爸爸这又看个了，爸爸帮你打多个，这个看。
Sir, may I continue, sir?
Yes, you start.
Sir. Akanksha, tell me what is the difference between evidence and a proof?
Sir, there is no difference basically.
Both are same things.
Yes, sir.
Are you sure?
Yes, sir.
There is no difference in a proof and evidence.
Yes, sir. There is no difference.
Okay. And what is the promissory estoppel?
So promissory estoppel is a kind of estoppel whereby a person is stopped after making a promise, and he cannot deny the content of his promise if another party is acting on it after the promise.
Okay.
Should I repeat it?
Okay. Photograph is a primary document or a secondary document?
So primary document.
Primary?
Yes, sir.
Photograph is a primary document. Okay. And what is the negative of the photographs?
Sir, sir, it will be a primary document. As per
Sorry?
the question before.
Both are primary document.
Sir, I
What
cannot
is the
recall.
patent ambiguity and latent ambiguity under the Indian Evidence Act?
The patent ambiguity is ambiguity which is apparent on the face of record of a document.
And latent?
Patent is which cannot be seen directly, but sir, there is ambiguity.
Can you just
Yes,
give me
example.
illustrations which can I able to understand?
Yes, sir. Sir, for example, if A promises B to provide him a house, he says that I will give you the house, so sell you the house situated in Allahabad or in Kanpur. Sir, this will be a patent ambiguity in the document because sir, here it can be seen that there is ambiguity that he is not sure and the consideration is not specific.
And what is a latent? Give me an illustration.
So just one moment, I need to recall.
Okay. When the person can prove the admission in his favor, what are the conditions?
The dying declaration and the entries made by him in the course of transaction.
And it is said that the admission cannot proved by the person who made it.
Yes, sir.
But there is a certain exceptions under the section 21 of the Indian Evidence Act. What are the exceptions here?
Sorry, sir, I'm not able. Yeah.
Whether you can be expert or not.
Yes, sir.
In which case, can you give me any circumstances?
Sir, if the handwriting of my friend is in question, whether it is handwriting of his or her, then if I'm acquainted with his handwriting, then I shall be an expert in that case.
Evidence has to be weighted, not to be counted. What does it mean?
So it means that there is no specific number of required evidences and no number of witnesses required.
Is there any
Particular number.
is there any
Yes.
provision under the Indian Evidence Act?
Section 1. So as far as I can recall, to section 132.
132. That is talks about the compelled witness.
So 134. Sir.
Okay. What is the limitation of estoppel?
The limitation of this estoppel includes if the person to whom the statement has been made has not acted on his representation, then the estoppel shall not be allowed.
Can the estoppel can be used against the act of the state?
No, sir.
Why? Is there any difference between legitimate expectation and estoppel?
Sorry, sir.
Have you heard the term of legitimate expectation?
Yes, sir.
So what is the difference?
This estoppel is basically a statement made by a private party, and who cannot deny the truth of his statement after the person has acted on his statement. But the legitimate expectation is the concern with the act of a state under an statute.
What is the residuary power of the Supreme Court?
Sir, it has been given under Article 142, 145, sir. Sir, under residuary powers, the Supreme Court can, for the interest of justice, the Supreme Court can uh, grant various judgments, can review the petitions.
Okay, suppose a non-cognizable offense has been committed.
Yes, sir.
And the NCR is lodged. And after taking the warrant, investigating officer initiate the investigation.
Yes, sir.
And after the completion of investigation, he submitted the report, whether this report is a complaint or a police report.
Sir, it will be considered as a complaint.
Complaint.
Yes.
After taking the warrant.
Sir, the offense was non-cognizable one. Sir, in such cases, the police report shall be considered as complaint.
In both cases, without taking the warrant or with warrant?
Sir, without taking the warrant.
So my question was, after taking the warrant, then
Then sir, it shall be considered as police report. And
okay, there are two proceedings going on parallelly. Okay, the first one is on the basis of the complaint, and second one is on the basis of the police report. Is the magistrate has any power
Yes, sir.
to stop the
Sir,
proceeding of complaint and initiate the proceeding of on the basis of police report?
yes, sir. Sir,
Where?
I cannot follow, but it has magistrate is empowered to do so.
So firstly, you have told me on the question of Jaswal sir, there is no provisions. If there is a FIR, cannot lodge the complaint. Hmm? What is the sedition?
So sedition is an act against the state, is an offense under RPC whereby a person or group of person is committing crimes against the state, like to throw the government, to uh, to override the government, and the implementation of rules, to intervene the public from doing his duty, and to certain other crimes.
No, it is not under the section 124 of the Indian Penal Code. What you were saying to me? What is the correct definition?
I cannot recall
Okay.
it.
My one last question. What is the jural postulate which was propounded by the Rasco Pound?
So there are certain presumption principles which Roscoe Pound talks about. There are four jural postulates. The sir, unable to recall it.
Okay. Thank you, beta. Thank you, sir.
Chitresh?
Akansha, can you hear me?
Yes, sir, now I can hear.
Sir, बाकी सभी लोगों को आवाज आ रही है?
सर आ रही है.
करेक्ट. आकांक्षा, आपने बोला कि you like the judgment which decriminalized adultery in India. What was the case? What was the name of that case?
So Joseph Stein versus Union of India.
Hello?
Yes, sir.
Yeah, Akansha, you like the judgment in Shabrimala case.
Yes, sir.
Okay. Why did you like that judgment?
Because sir, I was agreed with the judgment and the reasoning behind it.
What was the reasoning behind it?
Sir, the reasoning was that it is violation of rights of women, and sir, there is certain fundamental rights which were being violated by such prohibition.
Okay. It is being said by some schools of thought that applying a secular logic to a religious place is in itself very illogical, because by definition, it is a religious place. So how you can apply a secular logic to that place? What's your take on that?
Sir, religious freedoms are there under fundamental rights, but there are certain restrictions which, for example, if such religious rules are violating anyone's fundamental right, then such religious rules shall not be given priority. It's not absolute, sir.
This is not the question I asked.
Sir, if
My question is, can we apply secular logic to a religious place? Because by definition itself, it is being called a religious place. So can you apply secular logic to it?
sir, in modern times, uh, for improving the concept of secularity, we have to apply it, sir.
What do you understand by secularism?
So that state shall not support or reject any religion. Its state shall be unbiased on the point of religion, and it
What
shall
are the
treat equal all the religions.
You have mixed 2, 3 models of secularism in your definition.
So basically, my point is that, sir, state shall not support any religion, and there shall be no particular
No,
religion
your
of a
point
state.
is irrelevant here. The question is, what is secularism?
So secularism is equality of religions. All the religions are equal, being treated equal.
Okay. What is the difference between mistake of fact and mistake of law?
Sir, mistake of fact and mistake of law has, sir, under IPC, mistake of fact is excusable, but mistake of law is not. Mistake of law is that you don't know the law, but however, you shall be responsible if you are violating the law.
Can you give me an example? If I am a layman, I do not know what is the difference. Can you give me a simple example by which I can understand it?
Yes, sir.
You are permitted to use Hindi language if you feel more comfortable in giving that example.
Yes, sir. Sir, for example, uh, sir, if a person is there and he is thinking that there is an animal, uh, but in reality there is his child. But sir, he is believing him to be an animal because he is behind the bushes and he cannot recognize him properly. Then sir, if he shoots that person, his son, thinking that he is an animal, then it shall be considered as mistake of fact, and it shall be excusable under IPC. It shall not form any offense.
Okay.
So,
Akansha, who is a puny judge?
sorry, sir.
Okay. Akansha, suppose you get the result of your PCSJ and you get selected. What will be the first thing you will do?
Sir, in the field of sir, in the court or generally,
No,
sir?
after getting the news of your selection, what will be the first thing you will do?
Sir, I will communicate the result to my mother.
Why not father?
Sir, he is expired. He passed away.
Oh, so sorry. Okay. So now you have joined as a judge. You are done with your training and everything. You get posted at X place. What will be the first thing you will do there?
Sir, talking about my works, I will try to dispose of the cases, sir.
So that is naturally you will do. What will be the first thing you will do? The first step you want to do anything. जाते ही पहले दिन मैं ये काम करूंगी क्या करूंगी
Sir, I will maintain the office according to my needs.
क्या करोगे
Sir, I
ऑफिस
will
में?
manage.
What will you do in the?
Sir, I will manage the shelf according to my priorities.
Okay, what are your priorities?
So there are certain books which I love to read, sir. I will keep them in my shelf. I will manage my table according to my needs, and so this is the first step I'll do.
You like to read. Which is your favorite book?
So this is not my hobby. I have read so many novels, but sir, currently I am reading Bhagavad Gita.
Currently, you are reading Bhagavad Gita. What is the first slok of Bhagavad Gita?
Sir, the sloks are hard for me. I cannot recall.
What does the first slok say?
I'm not very expert in Sanskrit.
You don't need to recite the slok. You can simply tell what does it convey, the first slok.
Sir, I don't remember the first slok. Sir,
Okay. Do you think reading books like Bhagavad Gita and other religious books help in making a person a better judge?
yes, sir. I think so.
Why?
Because sir, there are many lines are there, and there are, for example, sir, yato dharmas tato jaya. Sir, these kind of lines encourage you and motivate you, and also puts your faith in the truthfulness, sir. And also, sir, these books can make you a better person after knowing the content of it.
What do you understand by dharma? You said yato dharma. What do you mean by dharma?
Sir, dharma is basically the words of a person.
Dharma is basically the
Words, sir. Not like religious. Sir, it is not concerned with the religion. It is by your words, like what you do, and
okay. What is the dharma of a judge?
to provide justice.
What is your definition of justice?
So my definition of justice is after considering the merit of the case, uh, act according to the law.
After considering the merit of the case and according to the law. This is a
Act
very
according.
bookish thing. This is definitely you're not a person's understanding. This you have picked up from some book. What is your understanding? How do you understand justice?
The truth is justice, in my opinion.
Truth is justice. Okay. Okay. So, Akansha, what's your take on All India Judicial Services?
Sir, in my
Why the,
opinion, it should. Yes,
why has the concept not seen the light of day?
because sir, many state thinks that the state central authority shall be imposed in an irrational manner over the states. Some of the states are not accepting that for that reason.
Is this the only reason?
Sir, I have read the reasons, but right now I can recall this reason only.
Okay. Thank you very much, Akansha. That will be all from my side. Over to you, Oja sir.
Sure. Sure. Akansha, purposely today I have changed order of preference of the interview panel. Generally, me and Shaur came at the last, other came early. I wanted you to make nervous at the initial stage. It was my purposeful attempt, not allowed to answer any question. You can't answer my question. If you answer those questions, I have the more questions to trap you. I don't want to answer you the question at all. Only because I want to check how you will perform after initial setback of 3-4 questions. Then I have taken the shore. In the shore also you asked the same, you was struggling. But the difference, I was purposely trying to trap you, shore was not purposely trying to trap you. Then the Om Prakash Jaiswal and Anu sir came, and you are very strong on the law. On that you are unbeatable. I believed it. उसमें आपको कोई दिक्कत नहीं है. But the most satisfying part for me that after making you nervous, you are sailed through. The experiment which I wanted, it has been proved very positively. Despite that you became nervous, but you recovered very fast. You was very nervous. In initial stage, you were very nervous. But as you started answering the questions, you was very good and you was answering very well. आपको law में कोई control नहीं कर सकता है. You are unbeatable law. It is my opinion. I again have the same opinion that I don't want to comment on merit. Merit part is very strong. You are a very strong girl. The opinion which we have, you will make your mark in the society and the exam. I have still on the same issue. I don't want to discuss the issues on the merit. आपने ये कहा वो कहा, उससे कोई बड़ा फर्क नहीं पड़ेगा. मैं पहले भी बोलता रहा हूँ कि लॉ के सवालों में 1-2 सवाल आपने आंसर किया नहीं किया, it doesn't make much difference. Although everything make a difference, you answer perfectly. But when you started analyze the things, then the opinion started changing about you. एक बात मैं जरूर कहूंगा, not only for you, most of the aspirants here, कि आप लोग जो बहुत ही इंपॉर्टेंट एस्पेक्ट सोसाइटी को डील करता है, कंट्रोल करता है, उस पर काम नहीं करते हो. बेसिकली आपकी गलती नहीं है. यू हैव नॉट बी ट्रेन्ड लाइक दिस. Wherever you have gone for the law guidance and coaching, all were have very confined towards the law only. Nobody has taken you to the task as we are taking. I think I'm right. Nobody has tried to acknowledge you. अब डेटा प्रोटेक्शन बिल है, फंडामेंटल राइट है, कहते हैं जुडिशरी का इशू है, बेसिक स्ट्रक्चर है. इस सारे इश्यूज का आप फैक्चुअल आंसर को मजा नहीं आता है. When you started analyzing, अब जो बेसिक स्ट्रक्चर का जो सवाल था, किसी पास आंसर नहीं है. आंसर क्या हो सकता था कि सर बेसिक स्ट्रक्चर डॉक्ट्रिन 1973 में बनी है, 40 साल बीत चुके हैं, 50 साल बीत चुके हैं. It need to be looked. No issue at all. It need to be seen. Nothing is sacrosanct. Even if you are going to have the same basic structure doctrine, then also you have to look into it. बड़ा परफेक्ट बैलेंस आंसर था ये. क्योंकि बेसिक स्ट्रक्चर डॉक्टर जो मैंने फैक्ट्स आपको, जो फैक्ट्स तो है ही है ना, यू कांट डिफाई दोस फैक्ट्स. और राजन गोगोई सर का ये आर्गुमेंट थोड़ी था इसको खत्म कर दो. दे आर आल्सो सेइंग इट नीड टू बी रिलुक्ड. जो सवाल संभवी के थे मैंने जानबूझ के रिपीट नहीं किया. आई वांट टू आंसर फ्रॉम यू आल्सो, क्योंकि आपने पूरा सुन लिया था. लेकिन आप संभवी का भी आपका जो कल के 2 इंटरव्यू रिपीट हुए हैं, आज जो रिपीट इंटरव्यू होते हैं वो बेटा डिफरेंट होते हैं. वो आपकी पर्सनालिटी को ज्यादा सामने लेके आते हैं. आप ठीक बोल लेते हो, आप आराम से बोलो, आपकी आज पेस भी ठीक थी, आपका जो आप पहले करते थे भी काफी कंट्रोल थे. यू सी द Sambhavi, she has done the more in comparison to you. She was faster than you. If I compare to both the girls, you and Sambhavi, then both have their own plus minus points. आप मेरे ख्याल से यही ड्रेस पहनने जा रहे हो, आपका ड्रेस परफेक्ट है. थोड़ा भी स्माइल और करना. जहां नहीं आता है साफ साफ ना बोल देना. देखिए अगर डेटा प्रोटेक्शन बिल पे, कहते हैं मणिपुर पे, जैसे मणिपुर में एक इशू था, सवाल मैंने पूछा बिकॉज आई डोंट वांट टू टेक वेरी लॉन्ग इंटरव्यू टुडे, कि मणिपुर में सुप्रीम कोर्ट ने एक कमेटी अपॉइंट कर दी है. आप पढ़ा होगा आज के पेपर में. अब वो कमेटी क्यों अपॉइंट की है? अब ये जुडिशियल एक्टिविज्म नहीं है. न्यूज पर बेटा आज का कल का 2 दिन का पढ़ के जाना. 3-4 न्यूज पेपर पढ़ो, एक बार पढ़ो, 3-4 पढ़ो. आप हिंदू पढ़ लो, एक्सप्रेस पढ़ लो, टाइम्स ऑफ इंडिया पढ़ लो. एग्जाम के लिए मत पढ़ो, ऐसे आप पढ़ लो. उससे क्या होता है, कई बार न्यूज़पेपर के करंट अफेयर्स के जो लॉ रिलेटेड इशू पूछ लेते हैं, तो जो आप जानते हो कि पूछने की संभावना है, why are you giving to chance not to answer? Rather you give chance to yourself to prepare and answer it. आपके पास बोलने की टेक्निक है. दूसरा, कोई चीज जैसे आपको लग जाए कि ये इंटरव्यू पैनल करेक्ट कर रहा है, अगर आप कन्विंस हो, it does not mean you surrender every time. अगर आप कन्विंस लगता है यार ये ठीक बोल रहे हैं, नथिंग रॉन्ग इन एक्सेप्टिंग इट, बट क्या करो थोड़ा आर्ट लगाओ। वाइल एक्सेप्टिंग आप वो अपने व्यू पॉइंट को, अपने मटेरियल को थोड़ा सा डाल दो उसमें। इंटरव्यू नीड a thinking person. If anyone asks to me what interview are seeing the candidate, I would say it want to see a thinking person. If you compare all the aspect of personality, your hobby, your education, your family background, everything, उसमें जो एक चीज उभरती है जिसके बारे में जो समाज में व्यक्ति काम कर सकता है, जो थिंकिंग है, जो सोचता है, विचार करता है, विश्लेषण करता है। तो मेरा क्या अभी लाइफ स्टार्ट हो रही है। Becoming a judge is not goal of life. It is just initiation of life. There's a long way to go. जज बनने के बाद आपको एक्चुअल काम स्टार्ट हुई। तो आप जज, आप नौकरी की तरह, अगर ऑनेस्टली देखा जाए, जज आप बनो नौकरी की तलाश में। हम चाहे जितनी कहानी बनावें, लेकिन सबसे प्राइम क्या, आपको नौकरी चाहिए। Seeing your background, if I analyze, you need a respect in the society. You want to fulfill the aspirations of your parents. You are more concerned about your father who is no more. When you were selected, you first remember your father. Your first mind कि today if he has been here, he would be very happy. एक कांस्टेबल की आप बच्चे हो, आप यहां तक अचीव किए हो, लाइफ का छोटा अचीवमेंट नहीं है, इट्स वेरी बिग अचीवमेंट, इट्स वेरी बिग अचीवमेंट। थोड़ा आपने बहुत कुछ अचीव किया है। मुझे आपके सिलेक्शन में पहले भी कोई संदेह नहीं था, आज भी नहीं था। मैंने बहुत ट्रैप किया, आप ट्रैप भी हो गए, लेकिन मुझे बहुत खुशी है कि आप उससे वापस आ गए थे। तो नर्वस मत होना, 2-4-5 सवाल का जवाब आया नहीं आया, कोई चिंता की बात नहीं है। आपका मेंस में मार्क्स अच्छा होगा, जिस तरह आपका लॉ को नॉलेज है, आपका मेंस मार्क्स अच्छा होगा। आप रैंक भी हायर पाओगे, आप कोई लोअर ऑर्डर की रैंक नहीं पाओगे। तो ऑल द बेस्ट। कुछ पूछना हो तो बताओ मेरे को, कोई सवाल बेटा?
यस सर। सर
बोलो।
सर अभी याद नहीं आ रहा है।
हाँ, याद नहीं आ रहा?
यस सर, क्वेश्चन सोचे थे लेकिन अभी याद नहीं आ रहा है।
याद कर लो, याद कर लो, याद कर लो, कोई बात नहीं है, मेरे पास सारा टाइम आपके लिए, आप याद कर लो। चित्रेश, आपका कोई ओपिनियन है?
हाँ सर, 2-3 चीजें हैं सर। एक तो जैसे आपने बोला, आपसे पूछा क्वेश्चन कि आपको कौन सा केस का जजमेंट अच्छा लगा, तो सर वो केस जिसमें एडल्ट्री को डिक्रिमिनलाइज किया गया, ये एक अच्छा इंप्रेशन नहीं छोड़ता है। आप केस का नाम बताओ ना।
ये बताओ
इसलिए
आकांक्षा,
मैंने आप
बात लेकिन ठीक, आकांक्षा आप उसमें केशव भारती केस क्यों नहीं बता देते हो? क्यों बता देते हो? आप बताओ क्यों बता सकते हो? आप क्या क्वेश्चन प्लांट कर रहे हो? वो केस बहुत अच्छा है। क्यों अच्छा है? उसने एक नई थ्योरी दी है, उसमें जो 7 और 6 का डिफरेंस वो है। बात चित्रेश की ठीक है, एडल्ट्री का जो केस है ये बड़ा अच्छा केस थोड़ी है यार। बात
नहीं
ठीक है।
सर, चलिए मैं सर इसमें सॉरी सर, आपको इंटरप्ट कर रहा हूं। मैं खाली ये कह रहा हूं कि अगर आप ये केस भी चूज कर रहे हो तो केस का नाम तो बताओ। आप शुरुआत केस के नाम के साथ करो कि सर रिसेंटली आई लाइक द जजमेंट इन द जोसेफ शाइन केस कि एडल्ट्री वाज डिक्रिमिनलाइज्ड, और उसका एक सर पर्टिकुलरली फॉर ऑल द फीमेल कैंडिडेट्स लॉजिक बड़ा अच्छा है कि एडल्ट्री वाज कंसीडर्ड अ क्राइम अगेंस्ट मैन। वो हस्बैंड के अगेंस्ट में क्राइम कंसीडर होता था पहले, क्योंकि औरत को तो प्रॉपर्टी की तरह ट्रीट किया जाता था। तो एटलीस्ट दैट पार्ट उसमें ये अच्छा है। सबरीमाला में मेरा रिकमेंडेशन रहेगा कि इस तरह का केस आप अगर ना जाएं वहां को तो बेटर है। इट्स अ वेरी ट्रिकी थिंग फॉर द पॉसिबिलिटी ऑफ टाइम, और बहुत लंबा हो गया था, आपका इंटरव्यू नजदीक है, इसलिए।
इवन आकांक्षा, एडीएम जबलपुर के बाद जो ऑर्डर दिया है धनंजय चंद, वो भी अच्छा केस है, थोड़ा पॉजिटिव। मैं एडल्ट्री के केस बहुत कन्विंस नहीं हूँ, मैं बहुत
मैं
अच्छा
सर
केस नहीं है।
सबरीमाला से कन्विंस नहीं हूँ।
हाँ, वो भी नहीं है। आप पॉजिटिव केस मेरा चूज करो ना।
सर रिसेंट केसेस याद कर।
भाई रिसेंट केस तो धनंजय चंचूड़ सर का जो केस है वो तो रिसेंट केस है ना। एडीएम जबलपुर को उन्होंने ओवरटर्न किया है। अगर रिसेंट केस को यूज करते तो है, अगर रिसेंट नहीं यूज करते, मतलब आप इसे सोच लेना इसमें। और बात ठीक है, जिस केस को आप चूज करो उसके बारे में थोड़ा सा डिटेल में जानकारी हो, उसके फैक्ट्स क्या है, फिगर्स क्या है।
उसके नाम से जरूर शुरुआत करो एटलीस्ट।
दूसरा क्या है, देखो अब ये सवाल के साथ क्या हो गया, ये सवाल आपने ही बना के बोर्ड को दिया है। A board is asking कि tell me about a case on which you want to discuss with me. It is the intention of the board, nothing else. It means board is wanting to frame a question. You have framed a question. Now you have framed the question. Your responsibility is the bigger here. You cannot say the question which I have framed I will not answer, or will answer half-heartedly. No, you cannot say this. मैं हमेशा बोलता हूं कि आप हॉबी पे, अपने बैकग्राउंड पे, अपने एजुकेशन पे, अपने फैमिली पे, अपने शहर पे आप सवाल आंसर नहीं करोगे, आई विल नॉट हैव गुड ओपिनियन, बिकॉज इट इज योर फ्रेम्ड क्वेश्चन। आपने खुद ही तो लिखा है कि मैं BLLB हूँ, मैं BHU से हूँ, मैं उनकी बेटी हूँ, मैं उनका उनका बेटा हूँ, मैं उस शहर में रहती हूँ, मेरी सिंगिंग हॉबी। आप ही तो बता रहे हो, हम थोड़ी बता रहे हैं। अब जो आप ही मुझको सवाल दे रहे हो, बोलो मैं इसका आंसर नहीं करूंगी, तो हाउ आई विल गुड ओपिनियन अबाउट यू। जैसे एक लड़की ने कहा था ना, मैं नाम मिस कर रहा हूँ, कि मेरी हॉबी रीडिंग है, उसने कुल 5 किताब पढ़ी है अभी तक। हम कहा नहीं, डोंट टेल यू, डोंट टेल दिस।
सर इन्हीं के इंटरव्यू में इसका एक और एग्जांपल दे देते हैं। मैंने इनको पूछा आपकी फेवरेट किताब कौन सी है, इन्होंने कहा सर ऐसे तो मैंने कई नॉवल पढ़ी हैं, लेकिन एक तो इन्होंने फेवरेट किताब का नाम नहीं बताया और बोला आजकल मैं भागवत गीता पढ़ रही हूँ, और फिर गीता का पहला श्लोक ये बता नहीं पाई। तो आप खुद भागवत गीता लेके आए, आपने गीता इंट्रोड्यूस कर दी आउट ऑफ डिस्कशन, जिसको आपको नहीं लाना चाहिए था। जब ले आए तो पहला श्लोक नहीं बता पा रहे हो, तो
देखो
दैट लीव्स अ बैड इंप्रेशन।
हाँ चित्रेश, क्या देखो, आप भगवत गीता एक ऐसा ग्रंथ है, सबको आता है,
हाँ
सबको आता है। तो
एग्जैक्टली।
ऐसी किताब अभी मैं अगर भगवत गीता ले रहा होता, मैंने क्या इंटरव्यू तुम्हारा शॉर्ट में बहुत लंबा नहीं कर जाता, भगवत गीता पे आप एक आंसर नहीं कर पाते, इतनी थ्योरी है, इतनी इंटरप्रिटेशन है। तो ऐसा देखो, क्या इंटरव्यू में क्वेश्चन सेट करने, जब आपको क्वेश्चन सेट करने का उसका एक आर्ट है। ऐसी किताब जो लोग कम पढ़े हैं, आप प्रेमचंद की गोदान बोल दो ना यार।
सर मैंने तो क्वेश्चन ही ये पूछा था कि फेवरेट किताब कौन सी है, कोई भी एक नॉर्मल सा नॉवल कहानी का नाम लेके निकल लेते साइड से।
अब भगवत गीता, तो भगवत गीता बोल दो, महाभारत बोल दो, रामायण बोल दो, फिर तो पता लगा कि वो लेके बैठ गया ना वो
पंडोरा
ये
बॉक्स।
सब। हाँ बेटा, आपकी उम्र कम है, अभी इतना आइडिया नहीं है, ये सब आर्ट है, सीखोगे। मेरे साथ आपका पहला इंटरव्यू है, दूसरा बेटा ये
दूसरा है सर रीडिंग मेरी हॉबी नहीं है, आपने पूछा इसलिए मैंने अभी का बता दिया। मैं अभी
तो नहीं नहीं, आकांक्षा क्यों बोल रहे हो, झूठ बोल दिया ना आपने। आप जस्ट सी द अदर पॉइंट ऑफ व्यू। अगर आपकी रीडिंग हॉबी नहीं आपने बोल दिया, तो झूठ बोल दिया ना आपने। क्यों बोलने का झूठ?
नहीं सर, इन्होंने ये तो बोला कि रीडिंग मेरी हॉबी नहीं है। मैंने इनसे पूछा फेवरेट किताब कौन सी है, आप बोल देते कि लॉ की ये वाली जो किताब है सर ये मुझे बड़ी अच्छी लगती है, बस लॉ की किताब का नाम ले लेते ना। जरूरी थोड़ी है कि आपको लॉ से बाहर की किताब का नाम लेना है।
तो क्या है आकांक्षा, थोड़ा हार्ड लक अपना क्या था कि हम लोग पास समय कम मिला, मेंस का रिजल्ट आया, आप लोगों से यहाँ लाते लाते 5-7 दिन बीत गया, तो हार्डली हम लोग 15-14 दिन ट्रेन कर पाए मैक्सिमम, इससे ज्यादा नहीं होगा। आप किस तारीख को आए थे मेरे पास? 7 या 8 को आए थे ना, कब आए थे? अगर ये हाँ, अगर ये दूसरा क्या है, आप लोगों ने गलती और की, आप लोगों ने सारे मॉक नहीं सुने। आप लोग सारे मॉक सुने होते, इंप्रूवमेंट हो गया होता।
मैंने सारे सुने हैं सर, मैं रिकॉर्डिंग सुनती हूँ।
बहुत बहुत अच्छा किया हुआ है। तो बेटा अगर लंबा टाइम मिलता तो और इम्प्रूव था। अगर दोबारा आप इस बार सिलेक्ट हो जाओगे, मान लो आप IAS देना चाहो, कोई एग्जाम देना चाहो, उसमें अगर मुलाकात होगी तो शायद और बेहतर काम कर पाएंगे। इन लिमिटेड टाइम काम बहुत कोशिश की गई, आप एक अच्छे कैंडिडेट हो, कोई बात नहीं है। ये जो छोटी छोटी मिस्टेक्स है तो ध्यान रखो। जैसे हमारी हॉबी रीडिंग नहीं, हम बोल रहे हैं, झूठ बोलते हैं, झूठ नहीं बोलने का बेटा, बिल्कुल बोलने का। बोल मेरे को हॉबी नहीं यार, व्हाट्स रॉन्ग इन इट। मेरे पास जब मैं पहला इंटरव्यू दिया, मैं कोई हॉबी, मतलब कोई हॉबी नहीं है।
नहीं सर, इन्होंने ये नहीं बोला था कि, इन्होंने ये नहीं बोला कि रीडिंग मेरी हॉबी है। ये तो इन्होंने बोला कि रीडिंग एज सच इज नॉट माय हॉबी, लेकिन फिर उसके बाद इन्होंने वो लाइन जोड़ दी कि बट करंटली आई एम रीडिंग भागवत गीता। वो लाइन बस नहीं जोड़नी थी, उतने से काम हो जाता। और एक एक सजेशन और है आकांक्षा, ओम प्रकाश सर ने आपसे, OP सर ने आपसे क्वेश्चन पूछा था आप क्या तैयार करके आई हैं, तो आपने बोला एविडेंस एक्ट, फिर उन्होंने कहा और कुछ, तो आपने कहा IPC, फिर उन्होंने कहा और भी चीजें कुछ, तो आपने कहा सर तैयार तो सब कुछ ही किया है, वहां तक तो ठीक था। फिर आपने लास्ट में एक क्वालिफिकेशन डाली, वो क्वालिफिकेशन क्या थी सर? कॉन्स्टिट्यूशन अभी कम तैयार किया है ना। गलती से भी ये नहीं बोलना है, ठीक है कोई चीज ज्यादा तैयार करी है ठीक है, लेकिन कोई चीज कम तैयार करी है और वो भी आप कॉन्स्टिट्यूशन को बोलो कि कम तैयार किया है ना, कभी नहीं। ये कभी मत करना, उसका नाम ही मत लो ना। ये क्यों बताना है कि कॉन्स्टिट्यूशन कम तैयार किया?
आकांक्षा, मेरी एडवाइस सबको होती है, शायद मैंने आप लोगों को कहा था फर्स्ट क्लास में, कॉन्स्टिट्यूशन नेशनल मूवमेंट ये तैयार करना ही करना है। ये सबको आता है, नहीं आता है तो भी आने का दम सबके पास है। तो आप बोलो हम कॉन्स्टिट्यूशन नहीं जानते, नेशनल मूड है। अगर आप एज ए पीसीएस एस्पायरेंट पूछा जाए आपको नेशनल मूड आता है नहीं आता, यू कांट से आई डू नॉट नो, यू हैव टू से आई नो इट। जानना भी चाहिए बेटा। जो पीसीएस जी के अपने पास जो बच्चे पढ़ते हैं उनको पूरा पढ़ाते हैं नेशनल मूवमेंट, पढ़ाते हैं। अब आप जो पीसीएस जी में टफ हो चुका है, उसका प्रीलिम्स आसान नहीं रह गया है। जो प्रीलिम्स जीएस का पेपर स्टैंडर्ड बहुत हाई हो चुका है, आपने दिया ही है इस बार। तो आई थिंक देयर इज नॉट मच इशू। जो चित्रेश जी बोल रहे हैं वो ठीक बोल रहे हैं, छोटी बातें ध्यान देना, बाकी सब अच्छा है, आप आराम से जाओ। जो मैंने सामूहिक राय मैं आपको दूंगा कि अपना वॉशरूम जरूर यूज करना, इट्स माई एडवाइस टू ऑल ऑफ यू। बिकॉज होता क्या, कई बार देर होता दिमाग सारा घूमने लगता है, दिमाग में कोई ऐसी चीज ना घूमे जो आपके परफॉर्मेंस को हैम्पर कर सके। इट इज माई सिंसियर एडवाइस, माई सिंसियर इंस्ट्रक्शन और सजेशन। बाकी आराम से रहो, 2-4 सवाल का आंसर नहीं आया कोई बात नहीं है। अभी मैंने 2-3-4 आर्टिकल अभी पोस्ट कर दिया, उसको पढ़ लेना, बाकी कुछ पढ़ने की जरूरत नहीं है। यू डोंट रीड टू नीड एनीथिंग, जस्ट आप न्यूज़पेपर आजकल का कल देख लेना, वो भी ऐसा नहीं कि एग्जाम के लिए, ऐसे कि अपनी आज देख लेते हैं, दैट्स ऑल। और कुछ सवाल बेटा हो गया? तो अब इलाहाबाद नहीं हो ना अभी, तो आप पहुंच गए हो ना इलाहाबाद, तो आप कल इंटरव्यू दो। अपनी माँ को याद करना, फिर पिता को याद करना, हम लोग आपके साथ ही हैं, जस्ट टेक केयर। अनुज जी कल आप चले जाइएगा। हाँ
सर
मेरा 28।
अच्छा आपका 28, अच्छा आपका कल नहीं है, अच्छा ओके ओके। मेरे ख्याल से इंटरव्यू सबका हो गया, एक मयंक का बचा हुआ है, बाकी सब लोग का हो गया है। चलो ओके, टेक केयर,
ऑल द बेस्ट आकांक्षा।
चलो ऑल द बेस्ट सर, प्रणाम।
ठीक सर, प्रणाम सर, प्रणाम।